Yes. No mentioning in the urgency.
No.
Why? Or mentioning just something.
Good morning.
Same to you. Well, one.
Well, we are putting our notes.
That I am filing the note. The thing is?
Teaching is not in the form of original statement. Kindly excuse us.
Already excused.
First.
Yes,
regarding Mr. Chakraborty's notes, I just want to appraise your lordship. Now, number one is one of the complainants has instructed him from the grave or through supernatural powers, because we
Not
have.
alive.
So I'm not object. He can do the needful.
Then we have to.
Then you have to amend.
Yes, you will not please.
Has to be
This is what we have
substituted also.
discovered.
Then you take out. If you have discovered, you take out. You are
Yes. You are the petitioner.
You are the appellant.
You are the appellant. Yes, appeal.
Order, my lord, please come to that folded sheet. Your lordship, my learned friend will confirm in terms of Order 22 Rule 10A, my lord. My lord, please see Agarwal Om Prakash, the folded sheet, my lord.
Yes, we are seeing that.
11415 is the gentleman's number. Now, my lord, on the next page, this is a newsletter of the institute. We find that Mr. Om Prakash Agarwal has passed away on 24th October 2017. That's number one. I don't know whether it's right or wrong.
Will you call the entire hearing and cancel the part?
No.
We're happy to do that.
I'm a statutory body. I don't have a problem with it.
So
Now,
we have to
Lord,
get
second
file an
problem.
application.
The second complainant, my lord, Mr. Shashi Agarwal, Lord, we'll have to see whether he's filed a vokalat number, because this, my lord, then we started inquiring. We contacted him. He said, I have not appeared. I have not given a vokalat number. So, my lord, that's also Mr. Shashi Agarwal.
Mr. Chakraborty, you take instruction on that.
The last complainant,
So obviously, I have not directly met him, maybe.
the Kesuram employee, my lord, I'm sure he's given a vokalat nama. But he was an employee of Kesuram Industries, so totally under their control. So I'm sure he's given a vokalat nama. My lord, we'll check all this, my lord, and mention before your lordship.
Should you take the written notes? You are taking the written notes, you are recording that.
Yes.
But you are recording your submission also, Mr. Chaudhary.
Yes, my lord. We will take steps for deletion of name. Or your lordship may please to, my lord.
Deletion will suffice because there is no question of substitution.
Yes.
His heirs don't carry the legacy
It's just a
of the
deletion.
complaint.
But Mr. Only, my lord,
You have to file a proper application.
We will do that. On a lighter note, my lord, how Mr. Chakraborty is received is not via, my lord, planchette or something.
He has those occult powers.
Yes. So that's what we will explore, my lord, outside the board, my lord, on the first floor.
Yes, and you can also, explore how.
Yes, so we will do that.
Other avenues.
But there are other people.
This will be helpful to. It should be public knowledge. All of us should know how to do it.
Mr. Aniruddha Chatterjee, Mr. Vishwarup Bhattacharya, we'll have to set up a committee to explore.
Written notes of arguments filed by the parties be kept on record. Full stop. At this juncture, learned senior counsel for the appellant apprises the court that apparently one of the respondents to complainants, Om Prakash Agarwal, has expired on October 24, 2017, which is evident from this is the newsletter or
of the institute.
Newsletter of the ICAI. Full stop. Next para. Accordingly, learned counsel for the said complainant shall furnish particulars of the date of death and or corroborate the information in writing by written communication to the learned advocate and record for the appellant within a week from date. Full stop. Next para. Liberty is given to the appellant to take out an appropriate application in that regard and mention the same for inclusion in the list.
And also,
mention the same for inclusion in the list.
Also, we'll check, the records to, see if Mr. Agarwal has filed a vokalat now.
That we are not recording now because we are not casting as per.
Checking,
Yes. If you find out it's not there, then just inform.
I'll inform him.
We can delete his name also, or we can say that he's a non-appearing party also.
We'll apply for deletion.
Yes. In your application also, you can put in some line. If
yes, we'll do that.
So we are not formally saying we are reserving judgment because that has to be corrected. The same day we'll allow that, and
The affidavit was filed for 2 and 4. Spot number 2 and 4.
K2K. Mr. Agarwal.
anyway, you check up. And
Uh-huh.
Mr. Chaudhary, you ensure that an one-page application is
Yes,
filed
yes,
for
to
deletion of the
bring
name.
correct the records.
Correct the record. Correct. Thank you.
Check the record once,
Yes,
my
yes,
lord.
yes.
In your lordship's
ये রেকর্ডটা দেখিয়ে দিই একবার অঙ্কুর পরে রেকর্ডটা ওনাকে পরে দেখিয়ে দিই।
Yes. I'm giving my reply to the argument.
So, Ghosh, we hate to say this, but we'd request you to just be brief because
Very
you
brief.
are brief in any event.
I'll be very brief.
But because of this bench is not regular now, it's very difficult to
I know.
juggle between the benches and.
Yes, I will be very brief.
Thanks.
Well, before Mr. Ghosh starts, I had a small point to point out. There's pleadings in the written statement. A small pleading.
Yes. Yeah. Point out so that Mr. Ghosh can deal with that also.
Yes. Yes. So it can be composite.
Please do it. Yes.
I am
Lord,
now only
yeah.
on point of law, my lord. It's just point
Yes,
of.
but let us see what they say. Mr. Ghosh, please take your seat and we'll just call upon. Yes, be brief, sir. Be brief.
I just have one page. My lord.
Yes.
If my lord could come to page 70 of the, it's the written statement. The written
70?
statement. 70.
First volume.
Yes, first volume.
Can ask you. Volume.
Yes.
বলো ভাই তাড়াতাড়ি বলো।
Yes, what is it?
তাড়াতাড়ি করো ভাই। হাফ এন আওয়ার লাগবে আমার শুধু।
The next matter is a dicey.
We'll try to ensure that Mr. Ghosh finishes before you come.
No, any event, Millard, I had Mr. Dasgupta, my junior Millard, spoke Millard for Millard half an hour. I haven't spoken.
Yes, sir.
Other side had whether
That does not mean automatically you get also half an hour.
no, whether it will continue here or the regular lordship will decide that.
Oh, acha.
Unnecessary Millard.
Yes, yes.
Millard, every day lordship has to sit.
We'll
because
consider.
of the-
We'll
ঠিক আছে
definitely.
বলো বলে দাও।
My lord has page 70.
70, yes, we have it.
My lord can come to page 80. It's the relevant paragraph.
Then why did you have space 80?
And that's
70?
the written state, first page of the written statement.
80, yes.
Yes. My lord, paragraph
70 is
10.
not the first page.
It's APDT 11, my lord, or APDT 8.
8. This is 8.
APDT 11 volume.
11 অন্যটা only that is on the in profits.
Yeah, but it has the written
No,
the copy of the written.
Very good.
Your lordship is not hearing this.
We were not hearing this.
We are not. Your lordship is hearing the other matter. These are mean profits appeal.
No, both the appeals are before us.
Yes.
Yes, both the appeals, but first is the question of eviction. Your lordship is hearing that.
I'm just showing the written statement, ma'am.
No,
And-
but we are hearing both, we suppose.
Yes, but yes. But
We are hearing
so far
both. Yes.
this is concerned, we'll take the question of maintainability.
Yes, what it
Lord,
Page-
paragraph 10, the last seventh line from the bottom, madam.
7th line, yes.
The lease in favor of the plaintiff having expired, the partners of defendant number 7 approached the plaintiff and the superior landlord Srimati Lolita Sadhukan, and it was thereafter agreed by and between the parties that the defendant number 7 would continue in occupation of the said premises as a monthly tenant directly under the superior landlord Srimati Lolita Sadhukan. Their case, as far as I could understand, my lord, was that they had returned to KOPT, and their pleadings is that they have returned to Srimati Lolita Sadhukan. So their case of attornment to the superior landlord is not met out in the pleadings.
Very well. Yes. That is. Thank you. Yes.
Yes, Milord. I'll be very, very brief. Only, Milord, my main point in reply is the respondents did not meet the point I had argued. Question of their locus standi before the lordships. They went on a question of AIR 85 Calcutta, Ganesh trading. There is a good judgment. Good, bad, or indifferent. Another division bench disagreed. That's the whole. Then they went to Ajaynath Ray, all this thing. I am not on that. After the disclosure of the documents, it is evident now. Question of title is totally. I am not asking whether the respondents have title or not, because after the decree has been passed against Lalita Sadhukan, all of us are trespassers so in the eye of CPT. Calcutta Port has obtained a decree. After that, all of us, no doubt. But I was in position throughout. The appellants was in position throughout. And that's why when they came to execute the decree, they found no one. And I can tell your Lordship without any shadow of doubt, the respondents were never in the suit premises. Two, when they came, that's why you came to Justice Mitra. Justice Mitra said that, your Lordship knows what that if you decree, if it is against you, then you must evict, must vacate. They said then the suit premises should have been returned to them and not to KPT. But it's a fallacious argument because supposing I lost before Justice Mitra, may I ask myself this question: to whom would the suit property would have gone back, reverted back? KPT? Supposing I lost in the Order 21, Rule 97. To whom the suit property would have gone back? KPT? So this argument is totally fallacious, and this has been adequately answered in Mimani's case. Which then, my lord, they had not at all attributed to what happens after the decree, which they suppressed throughout. Lalita Sadhukan did not at all, because when I made these pleadings, I did not know that Lalita Sadhukan had suffered a decree. We only came to know when they came to execute the decree, when KPT came to execute the decree. This was made in ignorance of all the relevant facts, material facts.
All right.
Even in 79, Lalita Sadhukan did not inform us that I should surrender the suit property to Calcutta Port Trust. For 12 years, she went on to enjoy. And we had paid even rent, and we had also liquidated respondents' dues through the income tax, which is a crown debt. Noted by the trial judge. We have acted so far as our returning back the property to KPT is concerned. My lord, before Justice Mitra, it was always Mr. Mitra allowed it because on the basis that KPT will get back the property. We acted my appellants acted most honorably. That no, my business is not doing well, it should go back to the Supreme Landlord. There's nothing hush-hush about it. The appellants, because the business was not doing well. Then,
Right.
now, my lord, the two judgments, my lord, I shall only these points were not answered by the respondent at all. That as to what is the locus standi today, I had relied upon two judgments. Mimani's case, he went on about the 85 Calcutta is good judgment. Then he said that distinguished D. Raman case. Those are totally redundant now after all the facts have been revealed. So these questions were not answered at all. Two judgments I cited, they had not been distinguished. But I have got some problem with my eyes, my lord. I will only request, my lord, if your lordship allows,
Yes,
Mr. Gupta to place only the relevant portions, not very few paragraphs from the judgment of Mimani versus S.K. Singh.
yes.
The other judgment is Charu Rizal.
Chowdhury.
Charu Rizal, this is your lordship's judgment. In Mimani's case, what happened, your lordship, I'll tell you briefly the facts. Mimani took a lease from the Dawes of Mangalhat in Howrah, about 8 acres of land, or 5 acres of land, for 50 years lease, which was expired in 89. In the meantime, there was a huge fire took place sometime in some mid-80s. The government took over from Himani's. And in the meantime, the lease also expired. Question arose that who will get the property? The supreme landlord or the Mimani? Mimani said, we should get that because we gave it to you, took it, the government took it from us. But eventually Supreme Court said, no, you are not in possession when the lease expired. After the lease expired, you were a trespasser and you have no estate in the property. And similarly, you also followed in the Charu Rizal's case also. That case, my lord, the property belongs to the Maliks of Marble Palace. The lease expired. Charu Rizal wanted to take the lease, fresh lease. And to it fresh, but there are various subleases. What are their status? Because once the main lease goes, all the subleases also go with it. And therefore, one person came and filed a suit and obtained an injunction which your lordship even doubted whether the suit was maintainable. In my opinion, also similarly, the suit is not maintainable by the respondents after the decree has been passed against Lalita Sadhukan. She kept quiet, respondents Pishima is Lalita. And they completely misled the appellant. Well, can you allow Mr. Gupta just to place few? Absolutely. So,
No. So I may be allowed to place para 30 of that judgment of 2001, volume 6, Mimani's case.
Yes, we have. Oh. Yes.
Mr. Nariman, in elucidation of section 108Q of the Act, contended that the lease has expired and there is no question of any doubt about the same, by reason wherefore the Mimanis have lost the right, title, and interest over and in respect of the leasehold property, being the subject matter of dispute and having regard to the provisions of section 108Q of the Act, the requirement of the concept of justice being of prime consideration. A short and simple question as to the existence of a right in favor of the Mimanis after the expiry of lease would answer the issue. Then you just go to the para 31. The fourth line. The factual aspect of the matter has to be gone into to make the provisions of law or judicial precedents applicable. The proposition which is noticed above pertains to the possessory right and eviction in accordance with law. The lessee has lost his possessory right and the same stands shifted onto the state. Once, however, the possessory right is transferred or shifted from the lessee and the lease deed stands terminated during the temporary interregnum when the lessee was deprived of his possession, question of putting back the lessee to the possession after expiry of lease in accordance with the provision of law does not and cannot arise. The court has to do equity, and in doing so, it has to consider the fact situation of the matter in issue, and it is only thereafter pass certain orders. Therefore, it is not an iota of right existing in favor of Mimanis to call for their possessory right. The right of the lessee stands obliterated by reason of efflux of time coupled with the issuance of requisition under the temporarily suspended, which temporarily suspend the lessee's right to occupy, though that does not put an end to lessor's right to own the premises unless, of course, acquisition follows, and so on. It is admitted that they have never been in possession because the suit is for recovery of possession from us. And it is an admitted position as well that they have lost right. Then para 36, Your Lordship.
Yes, 36.
36.
Hmm.
6 lines from the bottom.
Hmm.
The answer again cannot be put in the negative. There exists a differentiation between the lessee of a determined lease in possession and a lessee dispossessed. The Mimani stand admittedly dispossessed from the lease premises. Can any right be said to accrue in favor of Mimanis? The answer cannot be but an emphatic no. Law courts will have to act within the limits of law, and the courts try to take note of the moral fabric of the law. So, Lordship, facts are identical in case today. Now, I'll just read out paragraph 45 of 2025 AI 2020, the Charu diesel case.
Yes.
Para 45.
42.
45.
45. Yes. 45.
In Kevalchand Binani, it was reiterated that a person whose lease has expired is still entitled to maintain possessory rights so as long as until he is evicted by due process of law. However, it was observed that the said proposition was not applicable in the factual aspects of the case. The lessee had lost its possessory right and the same should shifted on the state. It was held in the said context that once the possessory right is transferred or shifted from the lessee and the lease deed stands terminated during the temporary interregnum, when the lessee is deprived of this possession, question of putting back the lessee to the possession after the expiry of the lease in accordance with the provision law does not and cannot rise. Next paragraph. In the present case as well, the plaintiff was not in actual physical possession in respect of the suit properties when Webel, its subtenant which is in physical possession, has handed over the possession to the appellants. The lease of the plaintiff has already expired at that point of time. Thus, on the strength of mere possessory right, the plaintiff could not file the suit for eviction. So that's what short submission is like.
Yes. Somebody, first.
Paragraph 54. The Lordship summary. In view of the above, we come to the following prima facie conclusions. The plaintiff not being in actual physical possession of the suit property, nor anymore a lessee in view of the termination of its lease, and the hence alleged by expiration does not have the locus standi to maintain the suit for possession. That's what it is.
And maybe 3 also. Webel is not barred by estable from disputing subsequent loss of title,
Subsequent.
which was a
Which was
argument
one of
116. And
Very much.
Fair. So that is all.
That's all. Lordship, with regard to the mean profit, once this is decided for or against, then we can argue on mean profit. Because we have not put forward our arguments on mean profit as such.
So then put it forward also. I mean, why wait for do it comprehensively? Do it
If your lordship dismisses, if your lordship
If
allows
eviction-
this appeal,
yes.
there is no point putting forward arguments on mean profit. It will unnecessarily take court's time.
If you don't do that, then what happens? Mean profit becomes relevant.
Then we argue it. In that case, we'll argue again. The second appeal.
So this is only
Eviction appeal.
which is APD 56.
Mm.
You or 183. APD 183 probably. This is just identify which item you are arguing. Which is eviction. Appear from the memorandum itself. Have the memorandum then. The volume was less, we would have found out by now. But the volume is so much we are not daring to go into the papers. You just tell us which
I
appeal is
believe
against.
it was APDT 8 of 2050.
186. 186. So we have then heard 183.
Yes, your lordship.
We'll make that clear in our today's order and request you to file, both of you to file brief written notes of argument.
Brief notice.
Brief notes because we have already taken our notes.
Yes.
So just point out, give the point.
Bullet points.
Bullet points. Soft bullets. So very well. hearing is concluded on APD 183 of 2015, comma, which arises out of the eviction suit. Full stop. Next para, learned counsel make it clear that that further arguments shall be advanced on APD 56 of 2015, comma, which arises out of the mean profits, comma, if necessary, comma, depending on the outcome of APD 183 of 2015. Full stop. Accordingly, oral arguments on APD 183 of 2015 are concluded, and learned counsel are requested to file their brief written notes of arguments on the said appeal. Within how much time can you do it?
Week.
1 week?
1 week.
Within 1 week. Within a week from date. Full stop. You just file it with your officers. We are not putting it in the list because
If-
we'll have to wait for some time for this bench.
We'll file it.
So we'll just both of you
We'll
file to our officer. অঙ্কুর নিয়ে নেবে নিলে ওনারা দিলে তারপর পাঠিয়ে please ensure that it's done within 1 week from today by next Friday
Yes, sir.
so that we can start on a judgment. Thank you.
Deep level.
We'll just put the main appeal then before the regular bench, otherwise
Yes, sir.
it will be difficult. সেটাই করছি APD 56 of 2015 shall be listed under the heading to be mentioned before the regular bench. অঙ্কুর তুমি টু বি মেনশনড ওদের বলে দেবে থেকে আর এক্সপ্লেন করে দেবে যে এই কারণে যাতে আমরা যখন নেবো তখন ওটাকে বলতে পারি একটা অ্যাডজাস্ট করে যে এটা থ্যাংক ইউ ভেরি মাচ
Lordship, the regular bench might not go to the bench having determination because this was assigned to your lordships.
oh this no assigned to a bench headed by me.
Yes, Lordship, but your
acha.
lordship's order says regular bench, it might not go again back to this. So,
No, why not? That is also a bench headed by me.
okay.
Yeah, the regular bench, the
The
regular
other regular bench, but the bench
regular-
having determination of this.
You're right. You're right. Then
In that case, this order will create a confusion.
well, ওই পার্টটা ছেড়ে দাও ওই APD shall be placed before the let it not be there, so we'll pass our judgment on this. On that date we'll also list this matter.
Yes,
যেদিন ওটা জাজমেন্টে থাকবে ফর জাজমেন্টে থাকবে তখন এটাও তলা দিবে we'll do that. We'll keep it along with the judge. Thank you so much.
Great.
Thank you so much. Yes, we are thankful to you for that. Of course. Yes. 5 year appearing? Yes.
My lord, Mr. Ghosh was here.
Yes, we ensure that it is done before he comes back. So Ghosh has kept his word on that also. You were arguing.
I am led by Mr. Debdut.
I mean, your side was arguing.
No, my lord, I am appearing for respondent numbers 3A and 3B. The
Yes, yes.
appellant, the appellant was arguing, my lord. I had taken a point of maintainability right in the beginning.
Oh,
That since this is an order granting unconditional leave to defend to the defendant to file written statement and contest the suit, this is not an order which is appealable, my lord. Does not fall under clause 15 also.
we heard you on that point only, maintainability point.
Lordship has not really heard them. They just mentioned the point. Lordship has heard me. But I am answering, and Lordship asked me to also consider. And
You have argued on merits as well.
And not entirely. It's a started point of laws, and then not.
Oh, we remember now. So we
There's the
requested
record, but not
Mr. Ghosh to
nothing it is.
Well, I think, my lord,
maintainability point you have raised already.
they have raised.
Sorry, they have raised already.
Yes. I think, my lord, to be very honest, it's a broken bench. My learned friend has only asked, my lord, now with the confirmation with this jersey, my lord, I have to be also fair to court also.
Because it was only the hearing was
Regular bench
barely started, Mr. Mukherjee. So I
আরে
think
অ্যাসাইন তো জজ সাহেবই থাকবেন কিন্তু ওনার the other junior brother judge will be changed. Assigned will remain with
Assignment.
we are
will
cancelling
Arthur.
the part heard because
That's
we'll record that it was the hearing barely commenced on the maintainability issue.
I said that, my lord, because I read Lordship has placed the facts.
We'll
I
record
only
that
have-
and because this bench is irregular. So
So, my lord, assigned means, my lord, this is assigned to a bench presided by my lord Justice Bhattacharya. So it will be before your lordship, but before sitting with Justice.
So we'll clarify that in our order. Learned counsel for the parties rightly point out that the hearing barely began and the respondents had indicated the objection as to maintainability. First up, since this bench is not sitting regularly, comma, the part hard marking is cancelled. First up, let the matter be listed before the regular bench headed by আমার পুরো নামটা দিন।
That's now the assignment.
Under the
rules.
heading to be mentioned. Let it appear as to be mentioned, and then we'll fix a date and hear it.
I'll take Millard. My outer limit is half an
Half an hour
half an hour to
on
40
merits as
minutes.
well as maintainability.
Merits, Millard. I'll just indicate judgment upon admission, Millard.
Oh yes, yes.
45 minutes. তার বেশি কি বলবো? তাহলে trial এ যেতে হবে।
30 minutes for you and 15 for him. So same allocation to you also.
Because today
Yes,
Lordship
yes,
has to sit because of the other matters. Again, for this matter,
absolutely
Lordship has
right.
to, Millard, constitute
No,
the
thank you,
bench
Mr.
and-
Ghosh. Fair enough. Yes, we were also saying that. Very good. Good.
I
Good
think
that.
that is Millard. Otherwise, Millard, my lord's Millard list gets Millard disturbed also.
Yes, yes, absolutely.
Grateful, my lord.
Thank you, sir.
I'm grateful to my lord.
Thank you. This was heard substantially or this?
No, it was heard. It was heard. Started. Mr. Dhiraj Trivedi was there with.
What?
Mr. Dhiraj Trivedi was there.
Oh, yes.
That issue whether he can appear anymore before the in a private litigation.
He has answered it by his absence.
Yes, I know. I also got the information. They cannot.
The indication that, well, as I'll
This is
begin then,
bad.
Yes, Mr. Mantri.
This is
Take your seat, Mr. Mr.
I'll just give a brief background. I'd already begun on the last occasion, but I must point out, Malas, that there was some,
Acha, can we put it before the regular bench?
as may I have no difficulty, Malas. I can,
Really started this matter. Because this bench is irregular. That's
I have
we
no
have to sit
difficulty.
for these matters.
I have no difficulty, Malas. I wouldn't object to that.
The less the better for this bench in the sense that the these are regular benches of both of us are being disturbed.
yes.
Yes,
We
yes.
can put it there.
A single bench.
Malas does that.
Since the hearing had barely commenced and this bench is not regularly sitting, comma, the part heard marking in the matter is cancelled.
Well, this is also
Push up.
assigned to my lord's.
The matter be listed before the regular bench headed by Amar Namde.
That.
That was the language of the
Yes, yes. That was the language of the assignment. Headed by
Grateful, Malas.
HON'BLE.
Well, it'll appear as to be mentioned. Your Lordship is request.
under the heading to be mentioned. No, it will appear as to be mentioned there so that we can put a date
Yes, Malas.
along with the other matters which similar matters.
Grateful, Malas.
Next, this Wednesday is a holiday.
You're so happy about it, and we are
Declare-
also happy.
That matter, well,
We can do
the other matter that is.
it as soon as possible. I mean,
Yes, Malas.
try to put it as to
Really,
be mentioned and pick the date.
Wednesdays are original side days.
Yes,
In the other, my lords.
Oh yes, yeah, right.
In the other matter, when I was arguing their suit for land, it is not in this Wednesday.
Yes, yes, yes.
This Wednesday is holiday. They're coming.
Whenever it appears,
Thereafter, it goes thereafter. Whatever. HON'BLE.
I'm grateful, Malas.
thank you. Something similar can be done in this matter also.
Yes, my lord.
Seven.
Yes, my lord. I am also appearing for respondent, my lord.
No,
Similar
respondent
things
for
can be
appellant.
done, my lord.
Yes, my lord.
Appellant, my lord.
Appellant,
Appellants.
appellant is required for that order.
Yes,
the
my lord.
appellant-
Victor Moses.
appellant is here. She is confused a bit. Madam, it's 7 item number.
My lord, I am
It's gone.
my lord, I am appearing on behalf of the appellants. My lord, I am led by Mr. Shuman Kumar Dotto in this matter. My lord, I am praying for a short passover, my lord.
Yes.
She did mess.
It's not her fault. No, let us not embarrass somebody.
Yes.
Mr. That should we put it before the regular bench? Because how long did you hear you? We do recollect it.
I'll take 10 minutes of your lordship's time. Either your lordship is with me or your lordship is not with me.
That's a
Within that
difficult
10
choice.
minutes.
We are always with you, but may not be with your proposition.
That's what I'm saying.
It's very difficult to be against you. Mr.
No, Millard. But thing is this, Millard, as I told you, your lordship had the occasion to hear me.
So it may be a short hearing also. Then
It will be a short hearing because I'll tell you, lordship, Millard, the only issue is there is a will. Will got probated by consent. 2 daughters obtained the probate from this court. Both appointed executors. Both reside abroad. One of them took up the responsibility to have the will probated. Dispute started once the will got probated. There, Millard, comes the question of putting in accounts. Now, Millard, so far as these accounts are concerned, Millard, they started making allegations against the other sister that, look, you are defalcating funds, this, that. On that allegation, once the executor was removed, the appeal court said, no, there is no such allegation to be sustained, and the appeal court restored the executor back. Ultimately, Millard, the accounts got audited. They went to this extent. There were two auditors, one appointed by court, one appointed by the executor.
All this is happening in the probate proceeding.
All this is happening in
After the probate was done.
after the probate. Now, Millard, when this auditor, court appointed auditor Millard has expressed in his report that I have not taken note of all the documents before me because the court did not give me leave to consider any document. It gave me leave only to audit the accounts. So, Millard, at the final hearing, that auditor's report was kept aside. And the auditor's report, which the executor had filed, was taken into consideration. Once it was taken into consideration, the auditor gave a list of expenses that were made. Millard, if it is part of the audit report, Millard, then he must have documents in support of it. The documents were before him. Now, Millard, the learned judge, with all the humility and respect, Millard, went into those accounts and Millard said that these are expenses I will not allow. Millard, thing is this, Millard, your lordship knows those expenses are admittedly made out of the estate, admittedly for the estate.
Expenses of the auditor.
Beg
Auditor's expenses. Expenses means?
Millard, these expenses have been made out of the estate by the executor for the purpose of maintenance of the estate. The auditor has said that these are expenses made for the maintenance of the estate. So, up till that, Millard, there is
What
no.
was the logic of refusing to grant this?
With respect, Millard, there are two items which probably will have some logic. He says that there are some restaurant bills and some telephone bills. This I will not allow. Negligible amount, Millard. The executor has his own explanation, but I also could not see how eating outside has any connection with. I could not find that to be, Millard.
The food was for thought.
Maybe, maybe.
So, but those maybe even without those, the rest at least should have been allowed.
Should have been allowed. If it is allowed, Millard, then time to time, as per directions of the court, Millard, I have paid them money in ad hoc. If that is allowed, Millard, then all I have to do is, Millard, your lordship will indicate which can be allowed.
You are the executor.
I am the executor. If your lordship
You have paid it from your pocket. You want a reimbursement.
I have paid it from the estate, which is now being disallowed. So I'll have to reimburse. So that's the point. Now, Millard, this is the point. If your lordship wants, I can start. If your lordship wants,
you have already ended.
Yes, I have. I
So
just
if you
need to
want
show 3 paragraphs of that order.
Yes, let us hear it out then.
My lord, my senior, I am led by Mr. Shauripto Banerjee, my lord. He will answer to all it. What my learned senior is saying is incorrect at all. There were 2 crores and odd money which she has spent out of the estate account without even asking permission from the court. For what purpose she is spending, my lord? If my lord kindly see, it's a very lengthy thing, my lord has to go
How
through.
long will it take the hearing? Mr. Dutt has made his point, made his argument in a nutshell. We will just show the judgment. The dispute is regarding the expenses borne out from the estate. Whether she has to reimburse them, he has to reimburse them or not. She reimburse them or not. Mr. Dutt pointed out, just to brief you up, pointed out that 2 expenses may be debatable. One is telephone exchanges, in its fairness, I mean, without considering anything. Telephone and eating out, those restaurants.
There are others.
There are others also, you see. So then we'll put it before the regular bench because this takes some time.
But because the provision of law, Malad, the first point that was taken by Mr. Dotto was, Malad, after grant of probate, the court becomes functus officio.
Yes, that is one of the points we have.
But that is not true, Malad. I will show from
no,
the
no, that definitely. Yes, that's an, all these are arguable things.
Malad, yes. Malad, it is arguable and
it requires some time. So we cannot finish
but
it. But
not much, but sometimes certainly, Malad.
So we may not be able to finish it by 1:15 today.
But other side would certainly require some time because they would show the audit report and everything.
So suppose now we are at 11:15, 10 minutes minus that break. 11:15 to 1:15, 2 hours.
তুমি তো audit report গুলো দেখাবে
1.5 ঘন্টা
আমি audit report করতে দেখাবো
45 minutes. Can you finish it by 40-45 minutes? You cannot be you are not sure.
40-45 minutes would be
difficult. So we'll put it before the regular.
I thought 2 hours. Your lordship was calculating 2 hours. So I said,
no. Once get divided between yourselves. You both of you.
45 minutes would, because there are 9 GAs which has been disposed of in one application. Then your lordship may be willing to go to those papers also.
ওই তাহলে similar order করে দাও একটা মতো যে barely comments regular bench headed by the presided over by court, headed by the assignmental language, presided over by. So we'll put it before the regular bench under the heading to be mentioned.
But
Two other matters have also gone like that. So we'll club them together under to be mentioned and fix a date for hearing those matters.
but kindly give some preference later, my lord, when this will
The
come
preference
to
is
the
the
other
order in
bench.
which they were appearing today. I mean, all of these only will appear under to be mentioned on.
But
On your side, we don't have.
But ultimately, we are at loss.
Everybody is at a loss if matters are delayed. So the entire system is at a loss, including us. So we'll try to be as fast as possible.
Madam Great.
That is the purpose of fixing it before the
Madam Great.
other
The
bench.
loss probably which my learned friend is trying to say is because after all the money is lying there. His client is not being able to put hands on the money with her because she can't spend it because she might have to give it back.
But she has her entitlement in that.
Of his father's property. I also have my entitlement to it.
Literally father's property. In this case.
In Bengali, it sounds
May
better.
not be a zamindari, but
Yes.
But in Bengali, it sounds
Bengali may
better.
not be a zamindari. That's why we covered that point.
Father was an Air India pilot.
Almost a zamindari. Maharaja. No, not zamindar, Maharaja. Greater than that.
But hard-earned money.
Every money is hard earned.
Great.
Can't see the difficulty sometimes, and sometimes you can see the difficulty. Compromise, you have to make compromises for getting money also. Soft earned money. So those compromises are also hard, very hard. Anyway.
But
Very good. We'll take it up in the regular bench. Justice, we won't trouble Justice Bhattacharya much on this because he has his regular bench also, which is in any event disrupted occasionally. Right. Next.
Number 8. 8, my lord, I appear for the appellant. My lord, I will, as per the last direction, my lord, I'm filing my affidavit in reply to the supplementary affidavit that they had filed. This was an appeal, my lord, from
Not to the supplement, to the opposition to the supplementary.
whatever. My lord, my lord, it is in compliance of my lord's last direction.
This is an affidavit in reply to what?
To the opposition to the supplementary affidavit filed by them.
So
we had.
very.
Lord, there's the preliminary prayer was, my lord, condonation of delay, to which, my lord, these pleadings have been filed in the GA1. My lord, only, my lord, this one
So
thing I want.
not a part hard matter in that sense. The
Yes.
condonation application is still pending.
Yes. My lord, may kindly keeps it in the regular bench.
The same order will pass in this. The same. All these go together there, and we'll fix a date for these matters and
Lordship is keeping it as to be mentioned.
to be mentioned. Because we want to fix dates on all of this.
Grateful.
It will be the same date as it was appearing in this list.
Yes,
it will just be transferred to that list.
Grateful.
Same. Again.
Number 9 and 10.
Sorry.
Lord,
One second. আরেকটা লাইন অ্যাড হয়ে যাবে আগেরটা যে affidavit in reply to the opposition to the supplementary affidavit, comma filed today, comma be kept on record. বলে তারপর Yes. Next matter, please.
my lord, I appear for the appellants. This matter, my lord, Lordship will remember I had started my arguments to some extent with regard to that revocation, my lord, of the power of attorney, after which, my lord, mortgage agreement was entered, my lord, and the property has been mortgaged.
Yes.
We will probably remember, my lord, I have shown, my lord, started showing the judgments, but my lord, I will take definitely some time. So,
Yes, Mr. Banerjee, that is what you have been hearing the last few matters. You were there online.
Yes, I heard, my lord.
Should you do the same thing here? We'll ask
Yes,
you.
only difference here, my lord, there is an interim order as far as I am concerned, not against me, the other, my lord, sufferers with regard to the decree. So that interim order may be extended to some time for a period, my lord, whichever lordship pleases, my lord.
Interim order will extend them. Same order যেটা আগেটা করলাম ওই এফিডেভিটটা ছাড়া মানে বাকিটা
Disposal of the appeal ছিল না?
Till disposal of
for some time for till the end of September or until further order.
It was still 31st of August, my lord.
We'll extend it till the end of September or until further order, whichever is there.
Very good.
বাকি অর্ডারটা সেম ওখানে যাবে আর তার সঙ্গে the interim order granted earlier is extended till September 30, 2026 or until further order, whichever is earlier.
And this was also, my lord, assigned before, my lord.
Yes, the same bunch of assignments.
Same.
Thank you for cooperating in this because otherwise it would be difficult to.
No, my lord, I understand, my lord, because the bench is obviously not the usual one, my lord. So, my lord, I
Yes.
understand. What
Now what we are doing, Mr. Banerjee and Mr. Dutt, is in the other bench, we are not marking any matter as part heard. We are now apprehensive. My bench is with Justice Uday Kumar, Justice Supratim Bhattacharya, and all those are haunting us. So that's why we are telling that we have substantially heard and putting it under the heading specially fixed. So
But
that
my lord, Mr. Dutt and myself are in safer hands because this is an assigned matter, not a part. So it will follow, my lord, wherever lordship.
no, yes. Unfortunately, yes.
My lord, 9 and 10, both, my lord, same order.
9 and 10, same order. Same order.
Grateful, my lord, deeply.
Thank you very much. 10 এ তাহলে ইন্টারিম অর্ডার যেখানে বললাম ইন্টারিম অর্ডার
10 ইন্টারিম অর্ডার ছিল 9 ইন্টারিম
ইন্টারিম অর্ডার না তাহলে তো কভার করে যাচ্ছে কভার করে
ইন্টারিম অর্ডার একটাতেই ছিল
না
একসঙ্গে রেখে দেবে very well
দুটোতেই থাকবে
whatever interim order was that we have said the interim order granted early so that covers everything.
Item number 11, I appear for the petitioner. Your Lordship, this is a matter where the disputes have been settled and we have paid the entire money as per the settlement amount. We like to withdraw instructions.
You are for the petitioner. You like to withdraw?
Yes. Review application.
We are so grateful to you for and your client.
I'm grateful, my lord.
Thank you. Miss Learned Counsel appearing for the petitioner review applicant submits that the matter has been settled mutually between the parties. So accordingly, the review applicant seeks to withdraw the application. Hence, RVWO 14 of 2026 is dismissed as withdrawn without an order as to costs. Thank you very much.
Grateful, Your Lordship.
What application? GA1 of 2026 filed in connection therewith stands disposed of accordingly. Thank you.
Grateful, Your Lordship.
Thank you.
Item number 12. Appear on behalf of
for the petitioner, my lord.
My lord,
I'm led by Mr. Tucker.
actually, my lord, this is the judgment passed by my lords. And
No. Review
It has to be
applications we
before
cannot.
bench, my lord.
This is our judge.
My lord, only request, my lord, I'm led by Mr. Tucker. My lord may kindly grant me an indulgence.
He was busy for some time.
My lord may kindly grant me an indulgence in this, my lord.
Because there's an apprehension that it may be over before Mr. Thakur comes.
No. My lord may. My lord may.
No. Either way, not against you necessarily.
My lord may kindly grant.
What is the review on?
My lord, there were certain, my lord, findings which, my lord, with, my lord, due, my lord,
You need not be apprehensive that this court will take it personally. Come on, it's a review application. It's a legal right.
Yes. My lord, there were certain, my lord, findings on which, my lord, the judgment would turn.
You just cut off the niceties. I mean,
yes, my
just
lord,
because you don't own the judgment.
My lord,
Yes.
my lord, but there were certain
What are the
findings.
errors in the judgment according to you?
My lord, for instance, my lord, there is one, my lord, in this judgment, there is one part which holds that this court approved the draft. My lord.
All right.
My lord,
This is that matter.
My lord.
Didn't you impose cost on him?
No, my lord.
You didn't. Now this time we will.
My lord,
We'd love to say
that
this
is
to
why,
Mr.
my lord,
Thakur, because he's so poker faced and serious.
My
We'd love to say this to Mr. Thakur.
My lord, however,
This stay petition is my learned friend pressing. Is he
No, no,
withdrawing the
my lord,
original?
that I have.
No, this is a review application.
My lord, it's a review. My lord, there's one application I filed, my lord, to bring on record.
Oh.
My lord, to bring on record.
Yes.
My lord, certain documents from the file, my lord, which would show, my lord, the errors apparent on the face of the record.
These documents were before the court when the judgment.
My lord, since my lord had the file.
Physically,
Yes,
those were there.
yes.
Very good.
However, my lord, they were not. My lord, there were certain issues. My lord, there were certain issues with respect to inspection, as a result of which, at the time of, my lord, hearing, we could not, my lord, peruse those documents, and therefore we had to bring those on record.
It is not argued. Can it?
My lord, no. My lord had referred to, my lord, those reports from the file, and in fact, it makes reference in the order.
This is regarding the execution.
My lord, the
execution case. Those were the bench considered these.
My lord, if I may give a background, this was the matter, my lord, where by the same order, three applications and petitions had been disposed of.
Mr. Original side had placed reports.
My lord, this arose from an award.
Yes.
Section 34, my section 34 was, my lord, dismissed. I had filed an execution with respect to an undertaking that was dismissed. And, my lord, the execution petition filed by, my lord, the respondents was allowed. Subsequent to, that order dated 24th September, 3 subsequent orders were passed in the execution. After the matter had reached quietus as a result of the 24th September order. Subsequent to that, there were orders made with respect to the execution, including a map to be added, which did not find any mention in the award or in the proceedings. It was a map.
This is neither discovery of new matter nor error apparent on the face of record. So you
Yeah.
have a challenge before a superior forum.
There are errors. Apparently, my only indulgence is let Mr. Thakkar ably assist my lords in that.
Then would be without business and the appellate side will flop. That's the difficult.
My lord, may kindly grant this, since it is, I understand the delicateness of this matter. However, there are errors apparent on the face of the record. It is not,
Indicate one or two.
Yeah, very well.
Prevent us from dismissing it right now.
Very well. My lord, may kindly take the judgment in review. Right. It will be part of the memorandum of review.
Yes, we have.
Take out the paragraphs. My lord, may straight away, take.
The Thakkar is in court. Stada? The Thakkar is in court.
My lord, I am not. My lord, I understand. My lord, he is not in court today.
He will be coming to court.
He is not in court today.
He will be coming to court.
I am not aware, my lord, unfortunately.
Then you do the matter.
My lord, he is not in station. He is not in town. If I have just received it. My lord, may kindly grant this indulgence. Yes. However, my lord was, my lord, may kindly, come straight to paragraph, 69. Or in fact, 70. What has approved it?
Mr. Banerjee is in this matter.
No. Yes. Appreciate, why I am asking for this indulgence.
No way.
He's the main architect.
He's the architect of this.
No, only defending him. Not the architect.
Defending. Not the architect.
You're the architect of the defense.
Yes.
Yes, Mr. Yeah. Mr. Chatterjee, you are beyond that point when you get intimidated by counsel, whichever counsel. You are beyond that point. So
I understand that. Only, I have just asked his indulgence, but very well. My lord, may kindly, I apologize. I said.
Courts love to give pep talk and then dismiss your appeal.
Precisely, my lord, may kindly.
That's the caveat we are putting on.
My lord, which is why, I am.
Pep talk and you start the matter, then we dismiss it.
My lord, which is why I am asking.
We will not dismiss it today, even if you are against you. You start the matter.
My lord, may kindly take paragraph 99. Since, my lord, I have.
70 or 9?
My lord, since my lord asked for, a few points.
What are the nature of the points which you will be making out? Just tell us that.
Right. My lord, yes.
You are not on discovery of new matter, on error apparent on the face of the
apparent on the face of the record.
Very well. We are clarifying this. Our view is that error apparent on the face of the record does not mean that the entire records will be re-argued.
My lord, Mr. Thakkar is online.
Oh, then we will hear him. এই একটু সামনের বইগুলো সরিয়ে দিতে এত বই হয়ে গেছে না স্ক্রিন দেখতে পাচ্ছি একটুখানি এপাশের কলামটা দিয়ে দাও কয়েকটা ব্যাস সাফিসিয়েন্ট এটা টাকার কোথায় দেখতে পাচ্ছি না
কি বলছো
অনলাইন ইজ নট देयर অন
very well
not there.
My lord, as a caveat, my lord, there are issues with the other paragraphs. Only what my lord had said, my lord, that my lord will not dismiss it. Therefore, my lord, I am showing perhaps, my lord may kindly take paragraph 99. My lord, this is, my lord, the point of, my lord, the court having approved the draft. My lord, I had shown, my leader, Mr. Thakkar, had shown, my lord, provisions from, my lord, the Civil Procedure Code, as also the original side rule.
If it's a legal error, then you challenge.
No, my lord, it is not. My lord, the point was that it is only in the court's domain to approve a draft.
There has to be an element of determination by the court.
It has to be, my lord, solely by the court. It is not, my lord, it is not a factor. Yes, my lord, it is not a factor
which the registrar could have applied any discretion to. It is a factor which only the court could have. My lord, may I show paragraph 99, my lord, at page 31. My lord, the previous paragraphs, in fact, my lord, may kindly take paragraph 98 above. Thus, the powers so exercised by the learned single judge were well within the periphery of the power vested in him by Order 21, Rule 34(3) of the series. My lord, may now take paragraph 99. The ministerial tasks of comparison between the maps, the schedule, and the draft deed, as well as other ancillary procedure, were left to the registrar. However, the learned single judge did not shirk his duty, but duly directed the reports of the registrar containing the altered draft deed and including the reports as to the comparisons with the map, etc., to be placed before the court on every occasion. Only after perusal of the reports placed before the court, as evident from the impugned orders, the orders in respect of alteration of the draft were passed by the court from time to time. My lord, first, and now my lord, paragraph 100 as well. Finally, upon such draft being finalized, it was directed to be executed and registered before the Registrar of Assurances, Hyderabad, in terms of the award. My lord, here, with my lord, humble, my lord, there are two errors apparent on the face of the record. First is, my lord, the court did not direct execution of the final draft. One. In fact, my lord, and this is, my lord, why my GA is there. In fact, my lord, the draft that was finally executed was not even a draft approved by the registrar. So not only did the court not approve this draft, but even assuming that delegation was allowed and the registrar had approved a draft, that was not even the draft that was, my lord, executed. However, I am on the first point. Primarily, my second, my lord, in my GA, I have in fact, my lord, set out a table of the differences between the draft approved by the registrar and, my lord, the actual draft which was executed.
So deed which was finally executed did not tally with the draft even approved by the
registrar. However, let us take, my lord, the draft approved by the registrar to be the final draft, my lord, for the sake of argument.
There are differences between.
Yes, my lord, but for the sake of argument, let us leave the differences aside. The draft approved by the registrar was not approved by the court. It was only after execution or only where the court was informed of it. The record would show, my lord, that no final draft was placed before the court. The court did not thereafter say, go ahead and execute it. It was, my lord, the registrar. It was, my lord, the registrar who approved the draft. And thereafter, my lord, the court was informed about it. So the error apparent on the face of record is.
You say the court did not direct execution of the final draft
of the final
or approve of it.
It was, my lord, an ex post approval, if at all. In as much as after execution, the court was informed of it. My lord, fortunately, my lord, Mr. Thakkar is here to relieve me. My lord.
Fortunately for you.
Fortunately for me.
Unfortunately for him, my lord. Unfortunately for me, my lord.
Fortunately for you, because we can see you where you are.
Yes, my lord. I'm sorry, my lord, I could not appear in person. My lord, I'll just take over from where Mr. Chadha concluded. I'll not repeat anything. My lord, the chart would show, I'm just getting my brief. That is one point. That is the first point. The second point is, your lordships have held that, and I'll bring in the facts later, but on the first point, I'll elaborate. The second point is, your lordships have held that an order under Order 34, Rule 2 need not be a reasoned order, as it is not appealable. That is the second finding of your lordships, my lord, because your lordships have held that the judge proceeded to pass an order rejecting my objections, considered my objections in the form of the reports which were placed before his lordship, but the reasons may not be apparent from the order because the reasons were not required to be given. under an order under Order 34, Rule 2. That, my lord, with the greatest of respect, my lord, lordship kindly consider Order 43 once, please, my lord. It is an appealable order. An order made under Order 34, Rule 2, expressly being an appealable order which is subject to appeal and subject to correction, it perhaps require, my lord, reasons to be given.
Order 34 Rule 2. 34 Rule 2.
Yes, because this is an order under Order.
No,
I'm sorry, Order 21. I'm sorry, Order 21, Rule 34, Sub Rule 2. I'm so sorry. Order 21. In execution, Order 21, Rule 34.
Yes, yes.
Sub Rule 2, being an appealable order under Order 43, Rule 1.
Right.
Then, my lord, the learned single judge was perhaps obliged to give some reasons, at least some reasons to show that he has considered the objections raised by me and why the same are not upheld.
All right.
Now here, my lords, your lordship has seen the three orders impugned. First order merely grants time. First order merely extends the time for the registrar to complete the exercise. The second order brings in the map, allows the registrar to consider a map which did not form part of the award, and permits the registrar to consider the map given by them with the map which formed part of a decree, which was also not part of the award. That is my decree, or my conveyance rather. To compare that map with the map which is now being provided by the award holder. The third order merely corrects typographical errors in the second order. So therefore, my lord, none of these orders show any consideration of my objections. Going back to my first case, that the objections were never placed before the learned single judge. Therefore, he had no occasion to consider them or approve the final deed. The final deed has to be approved by the learned judge in chambers. Taking up execution cases, here the matter was specifically assigned to his lordship. So his lordship had to put the imprimatur of the court on the final deed after negating my objections. So none of the three orders reflect the approval of the honorable judge to the final deed of conveyance. Third, the objections were not considered. Fourth, the reasons are not to be found, and perhaps reasons were required to be given because it is an appealable order.
Yes.
Now, my lord, if your lordship kindly have my application for stay once, please. Because there I have put in a narration. It's not come. It is, that brief is not here, man. Kindly permit Mr. Chadda to give your lordship the chart, page of the chart in the petition, please, my lord.
Actually served on, he was not filed, sir.
You don't have a copy of the application?
No, we have been
GA.
served, but I don't know, my lord, whether it has been taken on record by your lordships, because we have
initially there was another GA
originally, my lord, they had filed another GA
with a lot of allegations.
If I may just clarify, my lord, that had not been filed. It had been served on. It had been.
This GA has been served.
This one,
Form
wait,
1 of
the one on record. Unfortunately, my learned friend is talking about a GA that had been erroneously served to my learned friends. My learned
This
senior.
had been served. The one which
And did you get your second copy?
We had initially one copy, Mullah. Then on 17 July, we had Mullah a letter which says in the above matter, we had served upon your copy of the stay application passed. Please note that there were certain defects in document. Therefore, the document has now been cancelled and withdrawn.
Yes.
So we don't know which one was.
No second application was filed, served on you.
Yes, but the first application it was filed, Mullah. It can't be Mullah withdrawn.
They say that we are
Because that had a lot of allegations.
No, they are saying that that was never filed. The number was given to you.
Yes.
Which is this is which one?
From my
own application টা অঙ্কুর কোথায় গেল তাহলে? দুটো application we have only one.
Perhaps an advance copy was given, my lord, and not.
We don't know what is happening.
Let's check with the which one was
the number
183, 138 pages.
There cannot be two GA1s.
Yes, but we were given the impression that to first file
That is my
understanding.
affirm করেছে but file করেনি.
Yes, affirm but not file.
It could not have been numbered. Otherwise, there wouldn't be any GA. This would be GA2 then.
Before the second one was served and was on 17 July. Before that matter was appearing in my lord's list with the numbered.
Appearing before us. Before filing of this. This is affirmed on.
Hold on, due to business.
No, that's different.
Yes.
This has been filed on 20th of July 2026.
So it was called on before that. The first application.
First date this is 17 July.
We don't know what is happening. But 1st July, the memo was filed. And this has been filed on 20th of July. If there was any, first of all, if there was another GA1, there could not be, this would not be numbered as GA1.
So that is why it has been handed over to my lords today in court. It has
No,
not been filed.
no. Nothing has been handed over to us. Nothing has been handed over to us. Could not be handed over to us.
ওরা আগেরটাও তো ফাইল করেনি, তোমার ইমপ্রেশন দিয়ে যে ফাইল করেছে.
Yes, must be there. Did it appear before 20th of July?
I think yes, my lord. I'm just
Check. This is a very serious allegation.
Yes.
We'll have to inquire into it throughout.
That is not first check because that's sub. Most of them they have not filed. That's why they must have given you the impression it's been filed.
Because they say that we
I-
have that filing.
Yes, my instructions, it was not filed. My instructions, it was not filed. my
If
lord.
it was filed, Mr. Thakkar, then there could not be a second GA1.
Yes, the department, the
System
number,
does
the
not
computer
permit it.
number.
The computer
System
does
will
not
not permit it.
Yeah,
Yes,
will not permit that. Central.
AIS will. Yes.
There cannot be two
They must have got the number for the memorandum of review. They must have served as a copy of the review application.
In the
Then it
letter,
will
they
file, which
might
was
have
really not
written
filed.
one.
Then they must have filed later. That must be
Yes.
our confusion.
So which page of this?
Confusion created by us, Mr. Banerjee, not your confusion. I'm sorry for the confusion.
No doubt
Very
about that.
Successfully created.
No, my solicitor,
Successfully confused.
what my solicitor must have done, my lord, there's no other GA file. So he has himself ascribed the number GA1 and served it on
that is
Mr.
what he has
Banerjee's.
Yes.
Yeah, that is what he has done.
Yes.
He
That
has
is
put in the
obviously-
number by, yes, because
Give
it
us
couldn't
number.
have been. Now,
There
my
was
lord, so these
There was a movie called New Delhi Times. Before the murder took place, this person used to have the murders done and then report it. He was the first one to report it in his newspaper. It was done at midnight. Once he published but forgot to, the murder did not take place. So he got called out. So it's something similar.
That was Muller. I think either Frederick Fawcett. There was a book Muller which
It was an
original book
adaptation
Muller
of
will
that.
recall.
There was a book by Frederick Fawcett. Yes.
It was very good. It was very
Absolutely.
Muller, really good.
It was an adaptation from that book.
That's right.
Yes.
The newspaper was going down, then he devised on this, and then he was to have
Precisely.
get the first news.
It was taken from that.
That's
body lifted from there.
Correct.
Adaptation means body
Quite
lifted
a
from
good book at those days. Muller, I remember.
Yes. But what happens to your chart?
My lord, page 7.
No, page 7, please. No, before that, page 6. My lord, may I just interject once, please, if your lordship permits me? These are the two grounds for entertaining the review, my lord. With the greatest of respect, my lord, I say that the review is maintainable. Now, on merits, my lord, on this application, there are kindly have now paragraph 13 onwards. These are, my lord, matters of fact. 12 onwards, please. And then these are what we have, my lord, on inspection, the facts which we have gleaned from the inspection of the record before the registrar.
These documents were available at that point of time, Mr. Thakkar. These were not placed before the court.
No, my lord, the lay reports were called for by the court.
So many documents are before us, but we are not supposed to look into every document.
No, my lord. These were not, my lord, given inspection to us, nor were we given certified copies of these.
No, paragraph
As yet-
5, if you may assist my learned senior. Paragraph 5
Yes,
is
that's fine.
Then there would not be any end to litigation, Mr. Thakkar. If you permit in review documents which were there but not placed before us.
No, my lord, these were
Yes.
my lord, documents of which we did not have access. These are the documents maintained by the registrar. Its inspection was given
Now
only, my
how
lord,
could you get the documents? Now how
now
could you get
pursuant to yes, my lord, kindly have paragraph 5, pursuant to an order made by court. In another proceedings, my lord, appeals from the orders of the registrar His lordship specifically granted us permission to take inspection.
You could have asked
of
for
the-
that permission from the court on the last occasion also. What prevented you? Similar thing, exercise. If you asked, for the asking, we would have given you inspection. You have a right to inspect. Otherwise,
We have a right to
you can
inspect,
always
but I
file.
have-
You can always file a slip and have an inspection. There's a procedure for that, Mr. Thakur. You could have done that
Well,
previously also.
Kindly see paragraph 3 once, please, my lord. It's not that we have not made attempts. Kindly see paragraph 3 onwards.
Sir.
Somebody has taken responsibility for this, my lord. Are not supplied till date. And what we are told, my lord, what my instructions are, what we have been told is, or rather what my attorney has been told is, that these are documents of communications between the department, that is the registry.
Certified copy is usually not granted.
Yes, will not be granted. So, my
But
lord,
what
we
are
were
you
permitted.
placing before us now? These are also not certified copies.
These are also not certified copies. These is the information which my attorney has, on verification, on inspection, he has noted down, and as now my client has put on
That
notes.
is what we are saying. That could have been done precisely by you previously also when you did not get the certified copies of documents which are not part of the pleadings or exhibit or orders are generally not given, Mr. Thakur. That is the general impression. General
I
impression
follow.
I personally have. But
I follow, my lord. But, my lord, inspection requests are also made. Kindly see paragraph 4. Letters have been given for inspection.
Mr. Thakur, you could have just pointed out to the court and had these. So it is not that despite due diligence, you applied for certified copy on several occasions, written letters. Those were not given to you. Those were not supposed to be given to you. If you did not have inspection, you could have. It was merely for the asking. Would have granted you the leave to inspect. Who prevented you
follow
from
my-
doing what you have done now, post facto, from doing that previously? Because we have to be satisfied that despite your due diligence, you could not do this before the.
My lord, two things, my lord. When we proceeded in the appeal before your lordships, my lord, on the 3 orders which were there, it was our understanding and maybe the lawyer's misunderstanding of the factual position that these were not considered by his lordship, the learned single judge, while making the order. But your lordships were pleased to hold that from the lay reports, from the records of the department which your lordships were produced before your lordships called for and produced on going through those records, the honorable court was satisfied that indeed the learned single judge had perused the objections and ruled on the same.
We probably referred to the orders of the learned single judge. Did you
The
refer
orders
to
with the-
documents also?
No.
Did you refer to these documents also in our order?
Your lordship, kindly come to the order. Yes. Kindly come to the order once, please, man.
Yes.
Order under review.
Right. Para 99.
Memo.
These paragraphs, 92.
Kindly have paragraph in the memo, it's page number.
Para 98 to 100 have been placed before us.
Yes.
We say only after perusal of the reports placed before the court as evident from the impugned orders.
Yes.
The
Yes.
orders in respect of alteration of the draft were passed by the court. We refer
It's
to
from
orders
the-
placed before us.
No, my lord, your lordship also perusal of the reports also, my lord.
91. You know, the last sentence, my lord, if I may assist.
However, the appellant was conspicuous by its absence on each of the occasions when the detailed reports containing the objections and the findings of the registrar thereupon were placed before the learned single judge. And the learned single judge passed orders altering the draft. Those are reflected in the orders. We have referred to nothing which was not before us. How could we, without giving you appropriate notice? Mr. Thakur, we could not have referred to something without giving you notice that we are referring to this. We only relied on the orders, and that is evident from 91 read with 99 and 101, para 100. We relied on the orders and we say so also.
No, my lord, your lordship.
Because by its absence, there could not be an occasion where you are absent if it's not a part of the order. Only when the orders are passed, the matter is before the court, you could be absent. How could you be present in in an obscure office where it was being done or something like that?
Para
No, my lord.
90.
Yes. The lordships have recorded that, Lord, these orders were never appealed against. The registrar's order.
That is another point he's taking. Mr. Thakur is
Right,
taking that.
they never preferred any appeal. Your lordships will find in para 90.
Yes, otherwise, yes, there may be other. But the
We
very
are not appealing from the registrar's orders, my lord. We are not appeal here in
so
appeal
that's
from
a
the order.
different point, Mr. Thakur.
That's a different. We are not on that. We are not on that, my lord.
We are not on that. We are only on whether these documents should be looked into now, thereby permitting you to reopen the entire hearing, I mean, entire arguments. That is what we are on. Because then
Madam,
review
these are-
should be, I mean, widened beyond recognition. Order
No,
for-
madam, may I say, kindly consider this, madam.
Yes.
These are not records of the proceedings stricto sensu. These are records maintained by the court. These
No,
lay
our point
reports.
is different. Our point is, Mr. Thakur, what you are producing now before the court, if you can produce now, you could have done the same thing at the time of hearing or before the hearing. So these are not discovery of new matter, one. Secondly, it cannot be said to be error apparent on the face of the record. Record does not mean that every paper which is there in the records or in the office we are supposed to look into. That
No,
is what
that is.
This is not discovery of new matter. This matter was there.
Well, this is not discovery of new, but this
Review. We are on review scope only, Mr. Thakur. In a proper challenge, maybe you could have taken out something and we won't you know sufficiently better for us to advise you what you could have done if you prefer a challenge. There are provisions for that also. So para 90, 91, 98 to 100, we have referred to the orders and we have said that you were conspicuously absent means when the orders were passed. So therefore, we have referred to it may be a wrong reading, an erroneous reading on law or on fact, Mr. Thakur. We agree with that. It may be correct, may be erroneous, but that makes it amenable to an appeal, a challenge before a superior forum, not before a review application. Mr. Thakur, you have been muted from your end or
no.
Now
But may I just take your lordship to certain paragraphs of the order impugned, all of which will bear reference to these reports.
All right.
Arguments were advanced on the basis of these reports. Now, these lay reports were not accessible to us, your lordships. I bow down to what falls from your lordships, that we could have addressed your lordships on the purport of these lay reports by taking inspection at that time.
Yes.
That I bow down to your lordship. But that these reports had a bearing on the order, which is now I'm beseeching your lordship.
Satisfy us on that also, Mr. Thakur. Satisfy us on that. We'll
Yes, kindly have para 13 onwards, madam.
Yes, 13. The 13 is the arguments of appellant.
Yes.
I apologize, my lord. Paragraph 89 records that the reports were placed before, my lord. I apologize for interjecting, my lord. Perhaps this would.
Para 89.
My lord, I apologize.
That is thing.
They are not giving me the project.
You are relying on these. Now you are seeking to bring these on record.
Amongst other documents, these are the reports. Since my lord had inquired about the reports being referred to, not just the orders of the learned single judge. Paragraph 89 records that the reports were not placed before my lord.
All right. So if it is that these reports which were trying to say that these reports we read it wrongly and it was an error apparent on the face of record, we can look into that.
That is all that I'm saying. And my lord, we were not, your lordship has seen, we were not given certified copies, I understand. We may not be entitled to, but inspection also came after the order made.
You cannot grow wiser later on and say inspection was not given to me before the hearing.
No, we could have approached your lordship and your lordship would have given us inspection for the asking. That I bow down.
That is not a valid ground.
No. We should have asked inspection before this honorable court. When your lordships were taking up the appeal.
Just asked for the inspection and we would have granted you readily, in fact.
Yes.
Inspection, you have a right to inspect. And there is
I would think.
Say you applied for that repeatedly, you did not. This was never brought to our notice also. If you once said we had applied repeatedly and no inspection was given, the court would be the first entity which
Yes.
would give an inspection. I mean, you have
My
an
lord, if your lordships only see at that stage, my lord, when we were arguing the appeal,
Hmm.
he thought, my lord, that these reports had nothing on the objections which were raised by us. If your lordships kindly come back to the
Very
impugned orders once, not the order under review, please, my lords. Kindly
All
have the order of the learned single judge once, please.
all right. Yes. Where is
Kindly
that?
see the orders of the three orders of the learned single judge, which came up in review before your lordships, my lord.
This application also it's annexed.
Yes.
Yes, page number.
Give us the page numbers and we'll
120.
105 and all these.
137 is the first one.
137.
10 days up. Where are the rest of them?
105 there is some no this is report of the registrar. ওদের একবার ডেকে না তো আমরা ঘুরে আসি খুঁজুক তো Mr. Thakur, we are taking that break so that Mr. Chadha
Yes,
can
5 minutes.
Yes.
Yes, please. Wait for it. Bunch of
Yes.
My lord, only one
Yes.
of the orders impugned in the appeal, the
Yes.
original order under appeal has been annexed to the stay application that your lordships will find at page 137. This was the first order in the series of 3 orders.
All right.
Kindly have this order, please, my lords.
Yes. Yes.
Registrar original side has filed a detailed report dated 7th November 2025. From the report, it appears that he could not execute the deed in favor of the award holder since the award holder has filed 13 objections before the registrar. And for that reason, he could not finalize the deed which is required to be executed in view of the judgment and order passed by this court and so on. He also prays for some time to finalize and register. It is also informed that hearing of the objections filed by the award debtors has already been concluded for final disposal. Time is extended. So, my lord, from this order, it did not appear to us, my lord, I have to take responsibility. From this order, it did not appear to me that the learned single judge was considering any of the objections, because the learned single judge simply extended the time for the registrar to decide on the objections, because that is the third last paragraph, have already been concluded and for final disposal. So the objections were being considered and ruled upon by the registrar, not by the learned single judge. So this is the 10 December order which was challenged before your lordships, my lord. Then your lordships will, if Mr. Chadda, do you have the second order which was impugned, which is not appended to this paper book or stay application?
On the way.
My lord, the second order is not annexed. So I'm just getting a printout, my lord. My attorneys are, if Mr. Banerjee or Mr. Kaur have, my lord. So the second order, my lord, your lordships can take it from me, only ruled on the map. The learned registrar, the registrar expressed his difficulty to take a map on record because it did not form part of the decree, in this case, the award.
Right.
The learned single judge directed him that the conveyance which my clients have got has a map. So that map should be taken as the proof map compared with the map submitted now by the award holder. And kindly have this.
Mr. Kaur has handed over copies of the second order.
I'm so grateful to Mr. Kaur.
That's 19th December order, Mr.
19th December order, yes.
Yes.
Now, if your lordship see the 19th December order, this also has no reference to the objections, but to one that is on the map, which the learned judge has clarified.
To compare the deed with the map and the schedule.
Yes.
With the award as well as execute such.
So the only objection which the learned judge, this was not in fact an objection by us. This was a recording by the registrar that he cannot have a map when there is no parent map to the award.
Yes.
So he is appending a map to the conveyance. So therefore he places it before the court that there is no map. And
so that is also one of the grounds of the order under review, Mr. Thakkar, that you were conspicuous by your absence. These matters appeared in the list and these orders were passed.
Yes.
So you never took these objections before the learned single judge. That is one of the grounds of our order.
That is one of the grounds of your lordship's order, that the objections which were raised before your lordships in appeal.
Yes, you never took this point before the.
Yes, the appeal proceeded on the basis, my lord, that the learned judge had referred the matter to the registrar. He is disposed of the proceedings. Therefore, he is functus officio. That was the first limb of argument. Then we proceeded on the argument that the objections which were raised could not have been decided by the registrar but by the learned judge. Therefore, then to answer that, your lordships were pleased to hold that the learned judge has in fact adjudicated but was not required to pass a reasoned order.
Adjudicated expression was probably not used in our order.
I'm sorry, my lord. Adjudicated was kindly. I don't want to put words. I'm so sorry, my lord. Kindly have paragraph 70, 72, and 90, my lords, please, of the order under review.
Right.
Kindly have. I'm sorry, my lords, for the use of the wrong word.
No, Mr. Thakkar, you need not be so sorry for.
No, I have.
Yes.
Kindly have.
70,
paragraph 70, please, my lord.
71st, yes.
Yes. May I just place paragraph 70?
Yes.
Because your lordship's analysis starts at paragraph 58 onwards. Now, kindly have 70. 69, your lordships, consider order 21, rule 34, sub rule 3.
All right. Yes.
May I place from that, please, my lord?
Yes, yes.
First, the scope of objections by the judgment debtor under the said provision is not all encompassing, but is restricted solely to the draft which has been furnished by the decree holder. Secondly, now Malad kindly see, secondly, upon such objections being made, the court is not required under the said provisions to pass reasoned order or to specifically adjudicate on such objections, but is merely required to make such order as it thinks fit, approving or altering the draft. And then 70. In the present case, all the objections raised by the award debtor appellant before the registrar and his decisions thereon were incorporated by the registrar in his reports. Therefore, your lordships have considered the lay reports, which were duly placed before the court on different occasions. The said objections and the decisions of the registrar thereon, as part of the reports, are a part of the records of the present appeal and are perused by us as well. The lay reports were, my lord, not part of our stay application, or these were called for, my lord, because we did not have access. Substantial majority of such objections relate to the merits of the award, jurisdiction, etc. I'm not troubling your lordship with this. That is the section 47. Now kindly come to about 3 lines about that. In an exercise under Order 21, Rule 34(3), the judgment debtor is only permitted to object to the draft and the deeds submitted by the decree holder and no further. Hence, there is no substantive adjudication involved in such an exercise. The very nature of consideration of objections confined to the draft makes the exercise procedural in character, as opposed to a substantive adjudication on the executability of the decree or award. Hence, even if it were to be assumed that the court itself did not deal with the objections but merely approved the registrar's decision, no prejudice would be caused. Then kindly come to 72, please, Malad. Yes. Second component of 34(3) of Order 21 is that the order of the court contemplated therein is merely on the approval or alteration of the draft if the court so thinks fit. Conspicuously, the provision does not mandate the court to adjudicate on the merits of the objections at all or to pass reasoned orders thereon, but upon such objections being placed before the court, to make orders pertaining to the draft, either approving or altering the same in its discretion. Hence, the very premise of the challenge to the impugned orders is flimsy, since the court in its limited jurisdiction under so-and-so was not required at all to deal with substantive objections to the execution, which would come within the domain of Section 47 and not Order 21, Rule 34 thereof. Well, may I, if with your lordship's kind permission, Malad, may I just make 2 submissions on this paragraph 72? Yes. The first sentence, Malad, where your lordships hold the second component, is merely on the approval or alteration of the draft if the court so thinks. With this, I bow down to your lordships. But your lordships will find from the lay reports and the chronology of events which I have stated in this application that the final draft conveyance, which was approved by the registrar, was only in the evening of 6th of January. And the impugned orders are all before this. It was approved by the registrar in the evening of 6th of January and executed on the next date. I'm sorry, in the evening of 5th and executed on the 6th. The learned judge had no occasion to consider even the final draft which was approved by the registrar. Then, my lord, your lordship says, where your lordships deal with what is the nature or the scope of the objections which can be raised, I bow down to your lordships, my lord. But then the first limb of paragraph 72 itself, where your lordships have dealt with the second component, was not satisfied in this case. The draft finally approved by the registrar went straight for execution without consideration of his lordship. And now once there are objections which are there, what your lordships have held in the second part of paragraph 72, that these objections which would come within the domain of 47 and not 2134, this ruling is not there of the learned single judge. The learned single judge had no occasion to consider these objections because they were never placed before him. The lay reports do not show any of my objections recorded in the same lay reports. Your lordships will see the lay reports, please, my lord, and I have summed up what the lay reports have in my on inspection.
Now, we have held, rightly or wrongly, Mr. Thakkar, that learned single judge need not have adjudicated on the objections at all.
Yes. Now, my lord, where your lordships say that was not required to pass a reasoned order, there I beseech your lordships to kindly consider whether reasoned order is required to be made or not once the order is appealable under Order 43, my lord. Because your lordships have already held that reasons are required to be given for the appeal court to test the correctness of the order when it is assailed. So, my lord, once, and I was just applying the reverse logic, my lord, when an order is liable to a further assessment, then the learned trial court is obligated to give reasons, which the appeal court would then consider in appeal. Of course, my lord, the reasons would be limited to dealing with the objections which your lordships have, with the greatest of respect, my lord, rightly held that this cannot be 47 nature of objections. These are objections only on the draft which is provided, cannot be anything more. If, my lord, supposing, if I may, in what has actually happened in this case, the draft approved by the registrar says vacant possession is handed over. My client objects to vacant possession being handed over and objects to possession also being handed over, being recorded in the conveyance.
All right, all right.
Because my client says, I'm not in possession, the developer is in possession. So obviously he's entitled to raise that objection, my lord. Now that is what the learned single judge was required to adjudicate upon, whether vacant possession can be given or not. Whether it can be mentioned in the deed that it is vacant possession handed over, or whether it can be recorded in the deed at all that the vendor hands over possession. Because this is a registrar handing over possession. If at all. And when possession is not sought for in the execution case itself. If handing over of possession is not sought in the execution case, merely registration of conveyance is sought, then could the conveyance record this? But these are facts which the learned judge was not called upon to decide, my lords. I am not assailing before your lordships the correctness or otherwise of the draft deed of conveyance. That is not the subject matter of the appeal, was not the subject matter of the appeal which your lordships considered, or the subject matter of this review. Correctness or otherwise of the deed which is executed is not the subject matter. What is the subject matter is the procedure followed by the department and the orders impugned. Now, my lord, if your lordship sees the second order and the third order, your lordships will not find any mention there that the lay reports have the reasons or record my objections, or that the learned judge has ruled on these objections. Now, if you kindly come back to the stay petition once, please, my lord, because where I've given the chronology of facts. Why this map also came about is because the registrar expressed his difficulty to rely upon this map or accept the map, and therefore the litigant came before court. The lay report did not have anything on the map. That is why, my lord, now that the lay reports originals are before your lordships, can be called for. And my notings, which I have now reflected in my application, may be considered in the light of the lay reports now, and kindly permit me now to read the lay reports with your lordships. This, I agree, my lord, could have been done by us at the first instance when the appeal is heard. Nothing prevented us. I bow down to your lordship's observation apropos that. But it was our reading of the orders impugned that the orders impugned do not show that the lay reports had any objections of mine or the learned judge's consideration of the same. That is why, my lord, I beseech your lordships to consider the orders impugned again. And that is why when this finding came in the order now under review, my lord, that is when, my lord, I think we can say, my lord, Rip Van Winkle woke up from slumber, and, my lord, all this inspection was formally sought from court. Objection. That is what it is. I have to say what I have done. I sought earlier, unsuccessful, I should have come to court. But if this is something which is apparent on the record, no in-depth inspection is required. All that is required is the findings in the order under review to be read with the lay reports in the chronology which I've stated in my application considered. Because this we cannot have any dispute on, my lord. Because these are court proceedings, or court, but departmental proceedings. These are matters of fact on which there cannot be any dispute.
All right.
And apropos the adjudication part, my lord, and the reasons part, that, my lord, order 43 perhaps, my lord. Yes, reasons will be limited, my lord. I bow down to your lordships. Objections are limited, so reasons are also limited. but that no formal adjudication or expression of reasons is required, my lord. With the greatest of respect, my lord, that would be an error apparent on the face of the order. In paragraph 90 also, my lord, your lordships
Yes.
have considered the reports, which in my respectful submission have no mention of my objections. This is also reiterated in paragraph 89 of the order under review. Your lordships have paragraph 89 once, please, of the order under review.
We do have it.
Yes, even otherwise, kindly have, my lord. Kindly see this one. 89. Even otherwise, the reports filed by the registrar before the learned single judge, which have also been placed before us, contain all the objections raised by the award debtor appellant and the observations of the registrar on those. This, with the greatest of respect, my lord, would not be borne from the reports now, my lord. We have now been given inspection. We've made hand notings. My attorney has made hand notings, and the litigant has relied on the attorney to affirm his oath on them.
So you say that the reports did not contain the objections?
Did not contain even a single objection or the observations of the registrar on them.
On those.
Yes, yes.
Let us see on one or two of the reports. But this is subject to their objection, which they'll be entitled to argue that we cannot look into the reports. You cannot rely on the reports at this stage. But still, for comprehension, I mean, comprehensive arguments, we are permitting you to rely on those reports, Mr. Thakur, to make this point.
The reports are not reports were not given to us, my lord. These are our notings on the reports.
Achha, your notings of the reports.
The notings which my attorney made on inspection of the report, which now the litigant relying on the attorney has summed up in the application.
Oh.
These are not the reports because certified copies are not made available to us.
Right.
So, my lord, for completeness, perhaps, if your lordships would be call for the reports, please, my lord. And your lordships will read the reports in conjunction with my averments in the petition. If my averments in the petition,
so let us see your notings.
Yes, please, my lord.
I have example 1 or 2 at least.
Yes, please, my lord.
Page 54. Those are the.
Kindly give me 1 minute, please, my lord.
Yes.
I'm just.
If I may.
Yes.
Paragraph 5. It's Mr. Chadda. No.
If I may indicate, 7th November report is at page 45, printed, a typed copy at page 48 in chronological order.
These objections were filed before the registrar, Mr. Thakur.
Yes, my lord.
That is also one of the things we considered probably.
Yes, this is your lordship's. So, my lord, I'm not enhancing the scope of review because that would be a ground of appeal. The objections one placed before the registrar have to be placed by the registrar before the court.
To the court. That was your.
Yes, that was my argument. But then again, this your lordship's fine. That is on. I'm not on that. So your lordship's conclusion cannot be assailed in review. On the procedure to be followed, that is not that would be beyond the scope of review. I would not assail that.
Right.
But now, my lord, I am only on what the reports actually read, my lord, and whether the reports had anything on this, and whether the learned single judge could have considered anything on my objections.
This page 40. This is a version of the
report
of the registrar.
Yes. The report which is spread. Yes. The report which was considered by the court.
Your note of that report.
Yes.
Right. But that was also flagged as flag B, the communication by the advocates of SBPL. That was of SBPL. They had taken
Yes.
an objection. We are at page 48, Mr. Thakkar.
Yes,
If-
my lord, at 48.
After the bold, the paragraph after the bold letters.
Kindly give me a minute, my lord. I'm just coming to 48. Yes.
Yes, yes. After the bold paragraph, if you
Yes.
please, the undersigned, if you please read that, that would be.
This is from Khaitan and Company advocates on behalf of the award holder, my lord.
Yes.
Copy of the judgment and a draft deed of conveyance.
So there's no reference to any objection being raised by you, is there?
No, kindly come to the next page.
Next page, yes.
Page 14. However, keeping in mind, so here there was no objection. Here
Right.
we sought time. Kindly see, however, keeping in mind to provide opportunity to file objection by Mr. So-and-so representing against the draft deed in question, time has been given, undersigned will proceed, next date of. So time was granted to give objection.
Yes.
This is the first. Now kindly see the date, please, my lord, 7th November 2025. So this is what is considered, my lord, on the first impugned order.
So where is the report of the registrar which records that you have made your objection?
No, this is the time which is given. Now kindly come to
time given.
Yes.
It is unimportant.
Kindly come to now the 17th November report, which is at page 43.
43 printed copy was 48.
No, my lord. 43 is typed copy of 17th November report.
All right.
That was 7th. Now objections are received. Kindly come to the first paragraph. I'm sorry, the second paragraph after the bold, the last paragraph on page 1.
Yes.
Refers again to the communication received from the award holder. Then flag B, reference was fixed, copy of the order of reference proceeding dated same. Matter was forwarded, so he refers to his first report, which is flag C, which I just placed before your lordship. Then kindly come to file 6 applications, page 44, top paragraph on the top, last sent.
Filed 6 applications. We have found.
These are the objections.
Your objections, yes.
My objection. These are not placed before the learned court. I'm sorry, the learned judge.
No, objections are not placed before the
Yes, but that is what, my lord, that is what your lordships have found, that the objections are placed with the report, the learned, and the observations on the objections. Yes.
Let us just complete this report.
Yes, please, my lord. For giving proper opportunity to settle the draft, Mr. Khaitan, appearing for SBPL, has given the opportunity to file written reply against the objection of the proposed draft deed of conveyance. So-and-so is also directed to plan site plan. Copy of the reference is enclosed. And then kindly come to the last paragraph.
So they were to file reply.
They were to file reply.
So what is the report after that?
Yes. Kindly come to the next report in serial. So these are, my lord, kindly make a note, 7th November, 17th November, which were before the first order.
Yes.
Now kindly come to the next report, page 38, please.
So it goes backwards.
I'm sorry, yes, my lord.
No, why should you sorry for that?
I don't know how they've annexed it, but whatever logic they've used. Kindly come to page 34 is the handwritten, page 38 is the typed. Now this is a report, my lord, kindly come, I'm sorry, my lord, kindly come to page 40. This is a report after the first impugned order. It is 18 December. So in the first impugned order, his lordship had no occasion to consider any observations because the observations were not complete. Reply was sought from the award holder. Now kindly come to this report, please, my lord, which starts at 38. The orders are flags X1, X2, X3 at page 39.
Yes.
Then 39 refers to the order made by his lordship, my lord, of 10th of December. Then he refers to certain further orders which he has made. Then kindly come to page 40, refers to the plans. Then kindly see, however, till 17 December, neither any map or plan has been submitted by SBPL in view of the order dated 17 December, nor any communication. So 17 December is the order by which he rejected the plan. That your lordship will find in the second paragraph of page 40.
Yes.
On 16 December, the plan was filed by SBPL, the award holder. By a subsequent order, the undersigned directed to submit a copy of the map or plan as reflected in the award, duly signed by the arbitrator. So the map or plan that has been filed by SBPL can be compared. So what was submitted, my lord, did not form part of the decree. So the learned registrar refused to accept it, said, show me something which has been approved by the arbitrator, which forms part of the award. This was not done. 17th, they refused to accept service. Then it was sent through email. Then on 17, that is the date of his report, 17 December, he says, nothing has been given to me. Then kindly see next. It is most humbly submitted before your lordship that on 18 December, a draft deed, now this is again a new deed which is coming. A draft deed along with map plan has been submitted by the award holder, but these documents are not in compliance with the directions passed. So not on my objection. He is finding objections on the award holder's documents, my lord. Copy of the map plan as annexed with the nomination agreement and reflected in the award as well in the solemn judgment passed by your lordship is indispensable for comparing the map that has been filed. So he expresses his difficulty. The undersigned humbly submits that the draft deed could not be finalized and incidentally execution registration could not be completed due to the omission on the part of the award holder in complying with the directions. And then he places these facts. Now this results in the second order, my lord, by which the registrar is directed to compare the map appended to my conveyance with the map now provided by the award holder. Although that, because the registrar expresses difficulty, the map is not part of the award, so it's not part of the decree.
That's different. That's on a different.
That's on a, yes. So this is why, my lord, this is now the third report. This is now the report which is considered and ruled on in the second order, which is impugned. But here also, my lordship will not find any observations on my objections. Now kindly have the further report which is there then. 7, now the last report is dated 7 January 26, which is at page 31.
7 January report only, your objection is referred to only at page 33, the first bullet point.
Yes.
And where it says that application has been decided and such petition disposed of by the undersigned by the order dated signed. The order is annexed, but not the objection.
And my lord, this is after the deed is done. The conveyance is executed on 6. This is reporting compliance with the learned single judge's order. This is kindly see the last bullet point on that page, please, my lord. On the last page of the report, on 7 January, Jokanta Roy, Assistant Registrar, submitted a report. Deed of conveyance has been executed.
Yes.
So, my lord, my applications were all rejected by the order of 5th of January. Conveyance given filed by SBPL, approved by the registrar without placing the same before the court and executed. The learned single judge had no occasion of compliance with order 21-34-2 and 3. So these are the 3 reports, my lord, which were placed before the learned single judge and considered.
Let us come to order 21-34 once, Mr. Thakur.
Please, my lord. Only give me a minute.
Now, please come to 3.
Yes, sir.
Sub-rule 3, 34-3, where the judgmentator objects to the draft, his objections shall be stated in writing within such time, and the court may make such order approving or altering the draft as it thinks fit.
Yes.
He construed this to mean that not necessarily that the objections have to be dealt with specifically, But you say that first of all, since the objections are contemplated within this provision, so therefore, if objections are directed to be filed, it would not be meaningful unless the court at least has a look at that, look at those
Yes.
objections.
Yes.
May not be a detailed reasoned order, but at least addressed. Those
Yes.
objections are addressed first. Secondly, that the court shall make such order approving or altering the draft. So this includes this approving or altering the draft must necessarily include a consideration of the objections while doing so.
I bow down to your lordships.
All right.
In this case, the learned judge never approved the draft because the final draft which was approved was filed only on 5th at 6:30, approved by the registrar, executed. And the impugned orders do not show any approval of the court or consideration of my objections. Limited scope, yes, I bow down to your lordships. A very limited scope, only on the language of the deed, if I may put it that way. The wordings of the draft, I may raise objections because everything else is decided. But they have to meet the approval of court.
Your objections you also held probably something like this, that section 47 covered because executability. Like you are saying possession was not with you, those were
vacant possession.
So aren't those objections on the merits of the executability?
No, man, it's not on merits. If a deed of executability is, conveyance is to be registered.
Yes.
That is executed. The form in which the conveyance is to be registered, the wordings of that conveyance is what 34(3) contemplates. That is where vacant possession comes in. That is where my handing over possession comes in, because kindly contemplate, it puts me in jeopardy because I've already handed over possession to somebody else, the developer in this case. Now, if I place that objection before the learned judge will consider whether he will record vacant possession or not, whether he will record handing over of possession or not.
But at the end of the day, these are notional. I mean, you are not doing anything.
No, I've done. I raised these objections.
No, not objection. Because it's not you who are executing the deed in terms of the award, and notionally the court does it for you. I mean, it's in your version that as if you are executing, the court on your behalf does it.
So it says by the pen of the language used is award debtor by the pen of the registrar.
Right.
So, my lord, it's like my attorney is doing something, but the ramifications are mine, and that is why, my lord, the objections come in here. It's not that just that because the court does it, I get a blank chit. It does not give me indemnity. It does not protect me from, expose me to other litigations, protect me from other actions.
And in this particular case, those objections, I mean, even if those were to be turned down, they had to be turned down by adverting to them, at least cursorily by the court.
Yes.
That is some reason.
There has to be, yes. Those are and that is why, my lord, I say that the reports did not have the objections. They should have had. It is not for it is not, my lord, for the registrar to take upon himself the power under 34(3). He is only the, if I may say, the receiving office. The draft is filed by the award holder. The award debtor may not resist the draft, may not have any objection. Then it goes through. The minute the award debtor files objection, it is the duty of the registrar to place it before court and for the court to rule on those objections. 30 of the objections may be felt by one single sentence, my lord, that this is beyond 34. Order 21, Rule 34, as your lordships have held, this is the scope of 47, executability, etc., not relevant. They may be felt by one single line, but by that one single line has to be there, A, and the other objections on the wordings have to be considered. It is ultimately, my lord, the draft approved by court, kindly see. Approving or altering the draft.
That has to be by the court.
Yes, so my lord, here that is not there, because the draft was not before the court. The court only approved on the map or permitted the reliance on the map, but left it to the registrar to compare the map given by the decree holder with the map in my conveyance. That also, with the greatest of respect, could not have been done, because it is approval is of the court. Whatever semblance of adjudication is there in 34(3) is for the court, not for the department.
So first of all, your objections were not even placed by the court. It is not contemplated in 34(2) and 3. And secondly, there was no approval by the court of the draft even.
Yes.
It was drafted by the registrar, executed, and then there was no order approving that formally.
Yes. No.
After
That
it,
is why. Yes.
finally drawn.
Now, my lords, I would beseech your lordship that if your lordships were to kindly call for the reports, my lord, and kindly compare the reports. If your lordships allow me to raise this point, I am presupposing that your lordships will permit me to rely on these reports. But if your lordship is inclined to permit me to rely upon these reports, in spite of my not making a formal request to your lordships for inspection, and then, because again I say, my lord, the reports, the orders do not show any consideration that any observations were part of the reports. The orders don't say that. Orders under appeal do not
If
show
we
that.
find something palpable, maybe under 215, Article 215 also we have the power.
Yes, your lordship will correct your records.
And as a chartered high court also we have some powers. So if you feel that there is really some clear error which vitiates the records, then as a court of records we are entitled to do that.
Lordships can always cure the record.
Yes.
So that is why, my lord, I say that kindly do, when it is a matter of court records, my lord, and not inter-party records. I'm just drawing that distinction for your lordship. This had been inter-party records. Yes, I'm at a higher footing. I mean, the test is and 47 is much higher.
Yes, it is the court's records which you are seeking correction of.
Yes.
Very good.
Lay reports are also court records, and the order is also, my lord.
All right. So this is your argument.
And my lord, on the adjudication part, my lord, because some reasons have to be there, my lord. It can't be a blanket.
You mean Order 21 Rule 34(2)?
Yeah, 3, my lord.
3, rather.
Given the fact that it is an appealable order, some reasons are required, my lord, on the objections. And the orders impugned are bereft of any reasons because the objections were not considered.
All right.
These are, my lord, with respect, my lord. My lord, your lordships will of course decide.
Wouldn't you cite 20 judgments on the scope of review?
I don't think so.
They will do it and you will give reply.
I will do if they do it, but if your lordships are, if your lordship permit me,
not capable of citing 20.
If you're that, I don't think Mr. Corwell, my lord, on the law, my lord, I don't think, my lord, we will have any.
Let us see what he does, then we will come back to you.
My lord, only thing is, my lord, your lordships will of course decide the procedure. But if your lordships are with me that the lay reports should be considered, then my lord, the state, because my lord, kindly permit me to say this, because these are matters of fact which are brought about in the stay application for the first time.
Yes.
For the completeness of record, my lord, because this is a very valuable property in question. I will not be here in some other.
That's why you have added to your argument, Mr. Tucker, Article 215. That's why you have added to your argument, because we'll also. This is rather a notice to Mr. Court.
Yes, yes, my lord, I was just thinking, my lord.
Otherwise, it's very difficult for you to now come back and rely on those, Mr. Tucker. If you are not satisfied, we are telling you because why? Because those were. As you told you already, that inspection could have been asked for you. If not given to you, you could have asked for leave of court to have that inspection. You could have done whatever you did now, post facto, at that point of time. That is our point. So if you could do that, then it's, and this is not error apparent on face of record on that count. Reports.
No, reports, my lord, if they are face of record, if the reports form part of
face of record, but Mr. Tucker, probably it will be going too far to go into this. Yes, you may have a point in saying that if you rely on the reports, then those we make it a part of the record and a part of the basis of the order also.
Yes, although they were not part of the appeal papers.
Yes,
because
if you rely on the reports, then those.
Because that was the submission made. That was the submission made. Your lordships were called upon to rely on the reports.
Yes.
Although they were not part of the appeal papers. But I was just saying this, my lord, for your lordship's kind consideration. If my lords are pleased to consider my arguments on the first part, that the reports do not reflect this, and this whole narration of facts which have transpired in the registry, etc., and how these reports were prepared, these are matters of fact. If I made.
Which is that paragraph where we recorded that the reports, the objections were a part of the report which were placed before the court. One of the paragraphs which you.
Paragraph 89. 1 second, please.
99. Para 99.
89, if your lordship. I replaced reliance on several paragraphs.
Yes. You have referred to 89, 90. you have also referred to, we're telling you.
90 is for the reasons part.
Para 89 to 91 you have relied on, and 98 to 100 you have relied on. And probably some 72 or some 70, 69 and 70 also. So para 69, 70, 89 to 91 and 98 to 100. Sorry, 72 also you have relied on.
Yes, my lord.
72.
71 and 72, please, my lord, where your lordships hold.
69 to 72. we have-
Yes, yes, yes.
No, the 71 we have not recorded that.
71. Oh, your lordships have one. Kindly give me a minute, my lord.
Not 71, 89. We'll check up right now. Yes, para 89.
89 is very clear, my lord.
Which have been placed, reports filed by the registrar which have been placed before us. Single judge and
Yes.
contain
Yes.
all the objections raised by the award debtor, appellant, and the observations of the registrars on those. But
Yes.
if we say that you have a point in saying, arguing that, contained all the objections, this part is an error apparent on the face of the record.
Yes,
Because it
that's
contain all the objections.
it is not, my lord. Then kindly see 70 also, my lord. I'm sorry, my lord. 70 also this is recorded.
Yes.
In the present case, all the objections raised by the award debtor before the registrar and his decisions
Yes.
thereon were incorporated by the registrar in his reports, which were duly placed before the court on different occasions. This is what has persuaded your lordships, my lord, that this has been compliance, may not be in form, but in substance.
All right, all right, all right.
This is what has persuaded your lordships. The said objections and the decisions
Right.
are part of the reports, are a
Get it.
part of the records of the present appeal and are perused by us as well.
Yes.
So that is why this is what has persuaded your lordships, my lord.
Fine. Let
Now,
us
my
say,
lord, just one thing, my lord, if your lordships are with me that the review is maintainable, of course, on the merits is a different matter. If the review is maintainable on, then, my lord, it may be in the fitness of things your lordship will decide, my lord, for the sake of good record, completeness of record, whether they're dealing with
Mr.
this.
Thakkar, we don't understand this logic that review we have to decide, we admit it, hold it to be maintainable and then decide it. We don't agree with people on this.
Very
We
well, my
say
lord.
that either we have to be satisfied that maintainability is equivalent to merits of a review. If
Very
we
well.
hold that ultimately that we were wrong on this count, that count,
Very
the
well, my
review
lord.
may be regarding the whole of the order, it has been vitiated, so we recall it. A review may be of such a nature that we have to rehear you. And there are cases where a review is of such a nature that we outright say that without any further hearing that we were wrong, this order, we recall this order. We review and set it aside. I mean, or whatever language you use.
I follow, my lord, what procedure your lordship is
Without
adverting.
requiring any further hearing also, if you are sufficiently satisfied that you are right on the review, if it's rejected, no point entering into anything further. If we
I follow.
entertain it, then we can also finally decide recall the main order and pass it in a different way without further hearing on merits again. Depends on the nature of the review, on the ground of review.
I follow, man. If your lordship would kindly come to my stay application once, please.
Yes.
Paragraph 7, 8, 9. Kindly see 9, very important. Because your lordships have decided in the order impugned that the learned judge,
yes,
in the orders impugned before your lordships have held in the order under review that the learned judge had occasion to consider the final draft of conveyance. Now kindly see paragraph 9. These draft conveyance was filed at 6 p.m. Fresh draft of conveyance filed on 6 p.m. at 2nd January. Approved the order. No summons. Nothing was given to me. Now this is after the impugned orders have been made, which your lordships have held. The learned judge has approved. The learned judge had no occasion even to consider. It was no conveyance was placed before the learned judge. He had no occasion to approve the draft, which is finally approved by the registrar on 2nd of January, in terms of which the conveyance is executed.
The next order is passed by the learned judge when?
Recording compliance.
Recording compliance.
Yes, which is not a recording compliance, which was not a sale before your lordships.
Very.
So these facts, my lord, if are to be controverted, my lord, then an affidavit, your lordship will consider whether it is called for or not. Because these are now matters of fact which I am placing on record Although these are subsequent, as in subsequent to the orders of review, orders impugned, but these facts would show that the order under review.
Very well. Yes. Yes.
That is, I hope I've been able to express.
Yes. Right. So we'll hear Mr. Accord. Yes, Mr. Accord, one thing on the scope of these documents being looked into, we referred to categorically in several paragraphs of our order on the reports of the registrar, including the objections or something of that sort.
Yes.
So we prima facie think that we can look into those reports to ascertain the veracity of our observations, subject to what you say.
Lord, of course, Lord, I am not, Lord, questioning the power of court, but Lord, I am only questioning, Lord, the propriety of the application. Because if your Lordships, Lord, kindly take the review application first.
Yes.
Your Lordships will kindly come to para 3. Lord, if your Lordships kindly take para 3, says review applicant had made repeated efforts to inspect the records of reference number such and such well before hearing of APOT 1 of 2026. Inspection requests were made on 17 December 2025, 2nd January 2026, 13 January 2026, 27 January 2026, although inspection was ultimately permitted on 27 January 2026. Lord, pausing here for a moment, the matter was being heard by your Lordship. On 4th of February 2026, hearing was concluded and the judgment was delivered on 18th of February 2026. Not a single day when the matter was being heard, or even there before that, they made any prayer seeking inspection of these records. And Lord, when the documents were called for, they were well aware of the fact that the documents were lying in the court. So applying for copies or certified copies at the stage when the documents were lying before the court was absolutely fruitless, because your Lordships had the documents before your Lordships. And Lord, they could have easily, before the court, one mentioning would have been sufficient that we want to inspect the records and Lord, we want to argue on the documents which are produced before the court. Lord, not a single prayer was ever made. So basically, Lord, what they could have done and the deficiencies which are there, they're trying to, Lord, cover up the shortcomings of the deficiency at their part by filing a review application. Lord, the short point is that there are 13 orders that the registrar had passed. 13 orders, starting from 16th of November 2025 till 2nd of January 2026. There are 13 orders which the registrar had passed from time to time. And Lord, my learned friend, Lord, just as an example, if your Lordships, Lord, kindly come to page 48 once. This is, Lord, one of the orders which was passed on 7th of November.
Yes.
Lord, your Lordships will kindly see the third paragraph at page 48. In compliance with the judgment dated such and such, undersigned fixed a reference on 6th November in connection with the above referred matter, being reference number such and such, in presence of the learned advocate for both parties. In the reference, Mr. So-and-so, learned advocate representing India Media, prayed for granting him 4 weeks' time for filing objection against the draft deed which was served upon him by the learned advocate for SBPL infrastructure, etc. In keeping in mind the provide opportunity to file objection, the learned advocate has been given and a default, the undersigned will proceed. So time was extended up to 14 January. Now your Lordships will, 14th of November, your Lordships will kindly take page 54. These objections were filed. Now what are the objections? Lord, kindly ignore the general issue. Kindly come to the objections on the draft sale deed. These are the corrections which were suggested. Page 1, this correction. Page 2, these corrections. Page 3, these corrections. All these corrections were incorporated in the draft.
Incorporated?
Yes. Page 4, page 5, page 6 and 7, page 8, page 9. To the extent, Lord, these objections, Lord, were valid, they were incorporated.
But then the registrar decided which were valid and which were not.
No. সেটা order to দেখো
objections এই warranty থাকবে damages claim করতে পারবে
Kindly see, Lord, one objection at page 60. Kindly come to page, there's a heading called page 11. Has your Lordship seen that?
Yes.
They say paragraph 4 contains description of several warranties through subparagraph so and so India Media Service is unable to give and cannot give and refuses to give such warranties, etc. This is, Lord, there is a, in the havendum clause, there are certain, Lord, narratives which are normally generally given in the conveyance.
Yes.
They say that you delete this. Now, Lord, these are the kind of objections which were raised, which was ultimately
marketable title
forget about it. Paragraph ওই যেটা জজ সাহেবের কাছে প্লেস হয়েছিল page 39 না all these orders were placed. Okay, just like what no, where is those? Kindly give me 1 minute.
Yes.
Where is that? All the order, all these were placed before the court. Kindly, my Lord, come to page 39. Kindly come to page 39. 38, Lord, the order dated 18th December starts.
Yes.
Lord, kindly come to page 39.
Yes.
Around the middle, upon perusing a note dated such and such, erstwhile register original site by order date, your Lordship was further pleased to direct inter alia as follows. It is also informed that the hearing of the objections filed by the award daters has already been concluded for final disposal. Time is extended till 19th December. The undersigned further submits before your Lordship that the undersigned has passed several orders on 28th November, 4th December, 5th December, 9th December, 10th December, 15th December, 17th December, and 18th December after holding the instant reference proceeding. All these orders were placed before the learned judge.
Orders were placed.
Order.
Mr. Thakkar says orders. By the orders, the registrar adjudicated on their objections. The objections were not placed before the court at any point of time, even along with those orders or the reports.
Lord, I have twofold submissions on this.
Yes. He says that the reports, the objections also had to be placed before the court.
Yes. Now, Lord, insofar as the records are concerned, the records contain, Lord, the orders, also the objections, because your Lordships will
that
find...
we don't know because the reports don't indicate, because it's specifically because SBPL, the award holder's objection, the first report clearly indicates that that is flagged as flagged something. But subsequently, when they sought for opportunity, adjournment was given to them, time was given, they filed objection. Objection is referred to, but it's not stated that that objection is also flagged as flag B or C. Or
Lord, as of date, they have filed appeals against 6 or 7 of these orders. These appeals are pending. These are under the original side rules of the High Court. They have filed, and these appeals are pending. They have appealed against these orders. But what is material is this, that when these reports, Lord, came up for consideration before the court, and which we argued on the earlier occasion,
they did not take any objection.
They neither took objection, nor they had filed any application under the Order 34. Lord, Order 34, this was one of the arguments advanced by us, that when the matter came up, they could have raised the objection orally. They could have also filed an application under Order 34, that Order 21, Rule 34. Because these objections were
They were raised before the registrar.
Registrar.
Mr. Thakkar says that those should have been forwarded to the court also.
But they should have raised it before the court also. They should have appeared before the court. They should have said that these are the objections which has not been considered. At that stage, Lord, it was also their duty to point it out to the court.
Because the language is where the judgment debtor objects to the draft. The objection shall be stated in writing within such time, and the court shall make, and it's immediately followed by, and the court shall make such order approving or altering the draft.
Yes, but the point
so there's a connection between the objections and the alteration.
Lord, when the registrar passes an order and places it before the court, Lord, that these objections are still subsisting. Somebody has to bring it to the notice of the court that these objections are still subsisting. It has not been dealt with. That function was never discharged by them.
For the judge.
And these objections had to be on the draft itself. That means not on the merit of the draft. Once they make that objection, Lord, perhaps if they are aggrieved, which they have exercised their power by preferring an appeal, but when the matter was placed before the learned trial judge in execution,
when the matter was placed before the court, they did not raise objection at two levels. One is that the objections against the draft themselves they did not take before the court.
Correct.
They filed before the registrar. Secondly, they did not also take any objection as to their objections not being forwarded. So that was also not so at two
taken.
levels. They did not take any. They did not raise this question at all.
So how would the executing
The
court
first time before the appellate court they're taking it.
Yes. And not only that,
was probably dealt with in our order also.
Yes,
Order
your lordships have dealt with this.
Touched that
Yes,
point.
your lordship
argued by you. We have
your lordship has
accepted
dealt
that.
with it. But Lord, my primary objection is that I appear before the court. I failed to argue my case.
They did not even appear before the court.
They did not.
And that, yes.
They did not. They did not appear before the court. They did not even point out to the court that my objection is still subsisting. I am aggrieved by the disposal or non-disposal. That function was never discharged. Lord, but my foundation of my argument is that, Lord, your lordship's jurisdiction has been invoked under Order 47. Inability to argue a case at the appeal stage, in my humble submission, can't be a ground for review. Because these documents were there, available. A person had access to these documents through the court. Permission of the court could have been easily sought. And, Lord, it could have been brought to the notice of the court at that stage.
Very well. Mr. Could we understand that argument of yours? We hope we understand. No, the other aspect is, suppose it is brought to the notice of the court that in an order of court we have held that this has happened. I mean, happened means we are being very specific that the reports of the registrar also included those objections which are placed before the court. And that is one of the premises of our order. One of the premises, there are other premises also, which might have invalidated that premise also. We will look into that. But all the same, this we had held, that was one of the premises of our order, that these objections were part of the reports and placed before the court. If we find, if it is brought to the notice of the court by Order 47 or whatever means, if we find that that was a patently erroneous premise, their objections were never placed before the court at all. So there could not be a meaningful decision on whether the draft should be altered or accepted under 2134(3). There could not be a meaningful adjudication on that by the court, adjudication or whatever you call it. So if we find that the premise of our very order was wrong, whether we can recall it and rectify our order on that premise.
Lord,
because we are a court of records and these things are there.
I have twofold submissions on that. Lord, a wrong understanding or interpretation of a document by a court.
Isn't it a patent error?
It is not, Lord. I'll come to that. Because, Lord, a patent error is something which is not apparently affects the judgment.
Yes.
That is
judgment can be supported on other grounds, then it may not be
a patent error.
may not be German.
German.
Did not entail a review of that.
Absolutely.
Yes.
So, when a person is talking about a patent error, one has to show that such an error affects the judgment itself. Because if your lordship looks at the language of order 47.1, your lordships will find
has to go to the merits.
It has to
hit at the roots.
Hit at
Let
the
us come to order 47.
Yes. One instance is that there are certain documents which one could not bring it to the notice of the court. That is one way of looking at it. It was not in possession of. That is
So
not.
strictly speaking, we don't feel otherwise order 47 because this is not discovery of new matter.
Absolutely.
Error apparent on the face of record only on that count, which we are now discussing.
Error apparent on the face of the record, in my humble submission, should go to the root of the matter. It should affect the judgment.
Yes. A cosmetic review is not entailed.
Absolutely. And I'm
just because to make it.
One is
make the
cosmetic
records
review.
Correct.
The other is the luxury of litigation. One is a person who's capable of doing something at the stage of arguing. He doesn't do that. That's not a ground of review.
All right.
That can't be a ground of review. Not, I can understand the error is so patent that
vitiates the
order on merits. This is not one such case. And in fact, to find the error, your lordships really made an effort for all these.
Not so apparent.
No, but my learned friend took time to point out the error. The Supreme
due to our limitations.
No, no.
That cannot be determined. The court took time to understand
the Supreme Court is saying. That is what I'm not saying on my own. This is what the Supreme Court is saying. That if it takes time for the court to find the error or the counsel to point out the error, that shouldn't be a ground. But I am not going to that extent. I am saying that it must be an error apparent which vitiates the merit of the judgment. If your lordships looks at my lord's order, I mean, just for if your lordship kindly looks at my lord's order, that is page.
Yes.
Kindly, just paragraph 89 onwards. No. Just one second. Lord, if your lordships, Lord, kindly come to paragraph 84.
Yes.
This is Lord, just before I place this, Lord, the scope of the appeal was very, very limited. Lord, there is an award passed by the arbitrator allowing the claim for specific performance with a direction that you execute the conveyance. This is the award. Section 34 is dismissed. Execution application is filed. And in execution application, the court says you execute the conveyance. We are the review, that order was challenged on merit, those 3 orders, out of which one was a correction. The other 2 orders were challenged on merit. On merits, your lordships have dismissed the appeal. Now, my lord, in review, what is being sought to be said, that certain procedures on which your lordships have commented, the record needs to be corrected in respect of those observations. This is, Lord, the substance of the review.
Yes.
Now, Lord, your lordships may kindly come to paragraph 89 onwards. Para 90, 91, these are the 2 paragraphs, if your lordships, Lord.
Yes.
Kindly see the second sentence. All the orders impugned before us indicate that the reports were not only placed by the learned single judge, but prompted the learned single judge to issue further direction with a view to alter the draft which was initially submitted. As discussed above, under Rule 34(3) of the so and so, it is not required for the court to adjudicate or pass reasoned orders on the objections raised by the award debtor to the draft, but only upon consideration of such objections to pass necessary orders approving or altering the draft. It is evident why the provisions is such, since the said provision itself restricts the objection to the draft and the draft alone. Substantive objections to the very execution or executability of the award on a larger canvas could only have to be raised within the contemplation of Section 47 CPC before the regular executing court acting in such capacity by an independent application under 47 CPC and not before the learned judge in chamber operating within the parameters of Order 21 Rule 34(3). Even the award debtor appellant proceeded on such footing, since notably none of the objections were filed before the judge concerned but were taken out before the registrar. Nothing prevented the appellant to raise the objections before the learned judge himself and or point out to the learned judge that their objections were not being addressed properly by the registrar. So this is
we proceed also on a more basic premise.
Absolutely.
These objections should have been taken, were not taken, so can't.
That is the basis of your lordship's judgment.
That is one of the bases. Then we need not look into the merits of those.
Absolutely. This is what I was trying to point out, that Lord, your lordships proceeded on this basis.
Very well. So even if we committed an error in saying that the objections were a part of the reports, those objections were not taken by them. That is also one of our premises.
Yes.
So therefore, we cannot have a relook at those objections which we shut out in the impugn order.
Absolutely. Absolutely. This is the reason, Lord, why I raised that point. I say that in fact your lordship's judgment can't be touched on this, because your lordships have proceeded on, and Lord, whether Lord factually these form part of the records, that's flag A, flag B, flag C. Lord, these are not the matters, Lord, for consideration in the review stage. This could have been brought to your lordship's notice, Lord, with flag A, my objection is not there, or with flag B, my objection. This should have been raised before the learned single judge. When Lord his lordship was considering the draft or passing of the various orders from time to time, that should have been placed before the learned single judge. What the appeal court is going to do with this, even if supposing, Lord, there was some procedural irregularity, Lord, that can't be a ground before the appellate court without the ground having been raised before the learned trial judge.
If it could not be raised before the appellate court which you have held, cannot be held in looked into in review.
Absolutely. This is the short point that I wish to raise. Lord, judgments are there, but I don't want to pardon you.
Of review is what it is.
Yes, it can't go beyond 47, order 47.
Okay.
These are my humble submissions.
Since there are 2 minutes left on the clock, may I respond on the next week? Yes.
Third learned senior counsel appearing for the review applicant and the respondents in the review application, push up for rejoinder reply of the review applicant, the matter be listed on September. Oh.
Next
Friday.
Friday,
You don't know when we are sitting this. So we'll try to sit whenever.
In fact,
let us see. I mean, we don't know. Justice Bhattacharya has circuit in the indirect also. So it's a utter confusion. Last line ta কেটে দিন, হ্যাঁ ওইটা কেটে দিন, ওটা অন্যভাবে করে দিচ্ছি. List the matter for further hearing when this bench next reassembles. We'll put it in the list some days before that, so that you can have notice.
Great.
Well, may I be permitted to mention, my lord, item number 23 and 24. Lordship will recall, just before the bench changed, this matter was taken up on a Friday, my lord, under order 41. Lordship admitted the appeal, but on a point, Mr. Thakkar wanted to come back. And that coming back, my lord, resulted in the bench changing.
So it was not at all, not parted in that sense.
Not parted in that sense. Well, I was praying, my lord, if it is not possible to take it up today.
24-25 or 22-25?
24-25.
So you'll direct it to appear before the regular bench then?
It will be, well, if it is taken up today, my lord, your lordship can finish it off because it was just passing of the order was left. I will just recapitulate, my lord, 5 minutes.
We are sitting, this bench is sitting up to 3:30. So, Mr. Sen, please have someone remind us at say 3:20 or something like that.
So if it is not taken up, then your lordship will
pass an order that
so that it comes in the regular bench, my lord. Monday itself it may come, my lord, because
but now under what heading?
Heard the matter.
Order 41 was it was admitted under. It's a misappeal.
It's a misappeal.
Appearing as part heard matters.
We will put it as to be mentioned and fix a date then before that bench. On Monday it will come as to be mentioned.
Obliged.
Thank you. Call on the list. Judgment will
for the degree holder, my lord.
Yes. FAT 100 of 2022 is dismissed on contest. Can 5 of 2026 is dismissed on contest, the order for 2027. FAT 100 of 2022 is dismissed on contest as well, thereby affirming the impugned judgment. Marriage between the parties is hereby dissolved by a decree of divorce. No order is to cost. It is made clear that the above judgment shall not preclude the appellant wife from applying for permanent alimony before the jurisdictional court. If such an application is filed, the learned trial judge shall, upon permitting both parties to file their pleadings and affidavits of assets, and upon giving an opportunity of hearing to both the parties, decide the same independently in accordance with law, without being influenced unnecessarily by any of the observations made above. Formal decree be done upon.
কলমটা বেশ তো
দেখো, টু দেখো।
Item number 2.
FA 140 of 2024 is accordingly dismissed on contest without any orders to cost, thereby affirming the impugned judgment and degree. Interim orders vacated, formal degree be drawn up.
Very grateful, man. Very grateful.
Lord,
Yes, sir.
praying for stay because there was already an order of injunction. Order of
My lord, I
injunction
am opposing, my lord. Your lordship will kindly consider.
that was subsisting, my lord, not to create third party because we were being dispossessed forcibly.
Appeal is dismissed. The decree was
To create third party interest.
My lord, it was put into execution. That is
I was dispossessed forcibly. There was a subsisting order of injunction in 2 cans not to create third party interest, and thereafter another 2 cans for
stay won't suffice. I mean, they will have to grant an injunction, which will be we are not in season of the matter.
continue in the
We'll
form.
record your prayer and refuse it. After the above judgment is passed, comma, learned senior counsel appearing for the appellant makes a prayer for stay of operation of the above judgment and decree. However, comma, since we are apprised that the appellant has already been dispossessed pursuant to the eviction decree which was impugned in the appeal, comma, there is no scope for stay of operation of the above judgment. Accordingly, such prayer is refused.
grateful, man. Very grateful.
এটা অ্যাড হয়ে তারপর সই করব।
এটা কার? Obliged.
Item number 3.
Thus, from the aforementioned discussion, it can be said that the present list does not come outside the purview of Section 57B of the 1953 Act. As such, there is bar in the jurisdiction of the civil court to interfere in the present list. So the impugned judgment passed by the learned tribunal does not require interference.
Dismiss the order.
As such, WPLRT 70 of 2026 stands dismissed.
এটা দিন।
I dictated for the respondent, Malad, this has come at my instance. The appeals were disposed. Appeal was disposed of by virtue of the mediation terms of settlement, which was Malad, though this is final decree proceeding pending, there was no direction to send back the trial court records which had already arrived. Malad,
The mediation has been successful.
successful, decree drawn up, but there was no order with regard to the trial court records be sent down. Only that, and I'll put in the respondent, I'll put in the special messenger cause.
Learned counsel for the respondent submits that the mediation undertaken in the matter has culminated.
No, Malad, that order is already there.
Oh, it's already there.
It's already there. Only
Learned counsel for the respondent points out that the trial court records are still lying before this court. Full stop. Accordingly, the trial court records be sent down at the cost of the by special messenger at the cost of the respondent to be deposited within a week from date.
I'm extremely good.
Next.
Well, I'm for the petitioner.
Wait.
Well, it is well
For the state.
correction to be made.
Wait.
Well,
What correction we said?
well, 94. And it will lordship kindly certify.
No, we have the
2025. There is no wrong. But what is seed mailer? There is mailer 20 in place.
What is the correction you were asked? Where? Which paragraph?
Well, in the cause title.
Cause title.
Here there.
First.
Cause title of the writ petition.
It should be 2024, not
25. In
the order.
Instead of 24.
In the order portion, the
Order
year is
portion, that is
correct,
right.
but in the writs, my lord, the writ petition's cause title.
WPLRT 94 of 2024.
In the petition, my lord.
Petition.
No, in the order dated
Ordering
23rd of
portion is
July, in the ordering portion, it says WPLRT 94 of 2025.
That is correct.
Correct.
In the cost title also it's 94 of
Cost title-
2025 in the order.
Cause title of the writ petition with the certified copy, the original, possibly, my lord. The writ petition cause title is photocopied. In the writ petition's, it is 2024.
Petition, it was your error. So how can you correct that?
Well, so your lordship kindly, I am praying first for direction upon the concerned authority to just the department to
What
correct.
will the department do?
Well, man,
It's your application, writ petition, you mentioned it erroneously.
it is my lord that.
What can we do?
Well, that is my lord the 24 inspired.
How can we correct your writ petition after the matter is disposed of? In the order, the number is correct.
Number is correct.
Learned counsel for the petitioner submits that the writ petition contained an erroneous number inasmuch as the year of the writ petition was printed as 2024. Full stop. Next para. However, since we find that the number of the writ petition has been depicted correctly in the judgment dated July 23, 2026, there is no scope for any further direction being passed. Full stop. Accordingly, let the matter go out of the list. Next. এগুলো নিন আগে নামিয়ে তারপর কল করবেন নামিয়ে পেপারটা দিয়ে কল করবেন
Lordship, I am for the respondent in item number 6 and 7.
My lord, item number 6 is my modification application in the appeal, my lord, which was finally heard on 15 July, my lord, and judgment was delivered on 21st July. My lord, this modification
what modification?
My lord, modification application for the money which has been deposited by the appellant in terms of the interim order. That was not indicated at the time of final hearing, my lord. And that interim
You
order
are for the
was-
appellant, you are for the
I'm for
respondent.
the appellant.
Appellant. In
I'm,
the appellant.
I'm for the respondent, Lordship, in this
You are for
matter.
the yes.
And I have deposited the money, my lord, and the treasury challan also annexed with the modification application.
This was from a land acquisition case or what?
No, my lord, this appeal was arising out of the money suit, my lord, which they have instituted.
No, you had deposited the money as a condition for stay or what?
Yes, my lord.
Yes,
Condition.
Lordship. Lordship, it is that case where Khatiyan number is relevant for the deed.
What is relevant?
Khatiyan number. The respondent is challenging the Khatiyan number is not mentioned in the deed, but it was mentioned in the deed.
Acha, acha.
Lordship, the respondent wants to submit only one thing. The respondent has only.
What are you wanting now? You take back the withdraw that amount which was deposited. What amount was deposited? The entire decretal amount.
6 lakh amount, 6 lakh rupees has been
We are
deposited.
permitting them to withdraw that since the appeal has been allowed.
Lordship, the respondent wants to submit only one thing. The respondent has already preferred one SLP before the Honorable Supreme Court. That's only one to submit.
Learned counsel for the appellant submits that the appellant be permitted to withdraw the decretal amount which was deposited by the appellant during pendency of the appeal pursuant to the direction of the court. Full stop. Next parallel, counsel for the respondent submits that a special leave petition has been preferred against the judgment passed in the appeal, which is now pending. Full stop. Be that as it may, comma, since the appeal was allowed on contest, comma, leave is granted to the appellant to withdraw the decreted amount which was deposited by the appellant in connection with the appeal. Full stop. You had deposited with the registrar. Was there a direction for that to be invested somewhere?
Yes, my lord. Yes, my lord.
What
Page
was-
number 8, my lord.
Pardon?
Third paragraph. Register
At
general.
page 8, at page 8
Yes,
it is
my lord.
mentioned. Your
It's lying with the Registrar General that shall invest in the amount.
Which paragraph?
My lord, page number 8, paragraph 3, my lord.
Page 8
From
of
the
what? The application.
Application, modification applications, my lord.
Yes.
Page number 8, paragraph 3, my lord.
Very যেটা বললাম ওই the decretal amount such and such along with interest comma if any accrued thereon comma after deducting the statutory expenses.
much obliged.
Thank you. Both side নাম পেয়েছেন মেঘনা? Yes.
My application for contempt. My lord, contempt of my lord's order passed on 9th of December 2024. My lord, the order is there at page 131. My lord, I just indicate my lord did not take the trouble, my lord, to look at this one. My lord, there was a suit.
Yes.
Suit instituted by me, my lord, challenging a deed of conveyance executed in my learned friend's favor. My lord, we say that there was an agreement for sale, prior agreement for sale and prior deed of conveyance, but that is yet to be registered because of, my lord, that stamp duty, which is also, my lord, hearing. So, my lord, the registration is pending, but in the meantime, the property was, my lord, resold to him. So, my lord, the sale deed is bad, etc. And, my lord, we, my lord, prayed for an injunction so that, my lord, he cannot claim himself or project himself as the owner of the property in the meantime. We obtained an order of injunction, temporary order of injunction, from which my learned friend preferred an appeal. My lords were kind enough, my lord, to uphold the order, saying that, my lord, he cannot project himself as, my lord, the owner. My lord, after that, what he did, my lord, in so many litigations, my lord, there are properties tenanted. My lord, I have, my lord, filed suit for eviction, where, my lord, he took out applications, my lord, for addition of party, saying that he is, my lord, one of the co-owners of the property based on that particular instrument, which is under challenge, and, my lord, on which, my lord, this injunction application was, injunction
Those are
relief was
pleadings in
granted.
connection with the court proceeding.
Yes. Order 22, Rule 10 applications were filed indiscriminately. My lord, tenants were also, my lord, inducted. Page 131 is, my lord, the order. Now, my lord, in their affidavit in opposition, my lord, they have accepted they ought not to have done this.
Okay.
No, one thing.
2 seconds.
Yes. Yes.
My lord, page 131 is the order. If my lords kindly just, my lord, have a look at that.
We want to see the order which was affirmed.
Yes. My lord, the order is there at page 6.
Proclaiming and not projecting themselves
Yes.
as the co-owner of the property in any manner.
Page 128 is, my lord, the temporary order of injunction, which was, my lord, affirmed.
Where is the projection? Where,
Yes.
sure.
Now, my lord, kindly have a look at page 143. My lord, there is a suit pending, my lord, which is nothing to do with this matter. But, my lord, in that, my learned friend has taken out an application at page 143 My lord, the name of the applicant is at page 144. And my lord, what he says in this application is at page 145. I just show my lord one paragraph, paragraph 3 at page 145.
Yes.
And my lord, this goes on for so many matters. My lord, then again at page 157, my lord, there is an application in another proceeding.
So I need to file a contempt application with the trial court, merged
Lord,
into our order.
My lord,
It has been withdrawn by them.
Yes, Mr. Banerjee, we are speaking to you.
Yes, my lord. We had filed an application, but my lords were of the view that, my lord, this has now marched. So,
we were of the view.
my lord, kindly have a look at page 741.
741
means last volume, last page.
No, that was at what stage? In connection with what did you
My
observe?
lord, the violation of this order only, the injunction order. So, my lord, we filed a contempt application under section 10, my lord, for violation of that order.
Yes.
So, my lord's view was that, my lord, the order has now marched.
Our view in connection with what? In this contempt?
Yes. Kindly, my lord, turn to page 741, everything would be clear. Last volume, last page. And that's why, my lord, we withdraw, my lord, that application. This was, my lord, the first contempt in the point of time. Contempt of the temporary order of injunction passed by the learned trial court.
Is just withdrawal order.
Yes, my lord, that
Before
was of
Justice
the
Bosak and Justice
yes, my lord, the honorable division bench was of the view that, my lord, this has marched. Then, my lord, Justice Bosak's division bench was taking up, my lord, section 10 contempt matters. So he filed, my lord, a section 10 contempt.
So the CPN 1813 of 2024 was dismissed as withdrawn. This was in connection with that.
Temporary order of injunction by, my lord, trial court. Violation of that order we had alleged.
No, you could have taken up proceedings under the appropriate provisions of order
39 2A.
Yes.
39 2A. But 39 2A is, my lord, one recourse, subject to, of course, correction by your lordship. But
The other order of the trial court, which has we have just affirmed it.
My lord, with reasons. Kunai Ahmed, if, my lord, that is, my lord, I rely upon.
Anyway, yes. So
and, my lord, their affirmment at page, my lord, 20 of their opposition. Oh, and I'm sorry.
Question টা কোথাও ওদের? That's a reply. It is reply. এটাতে একটা
Oh, ইয়ারি করি
opposition.
আচ্ছা
তাহলে এখানে থাকবে page. Yes,
I did not notice when
which page?
Mojumdar is reading. My lord, page 20.
Yes.
My lord, clause O and clause B. This is his stand, my lord, today in this contempt proceeding.
Do they tender any apology in this opposition?
Not really.
So
And, my lord, page 17, clause H. Achha. Page 17, my lord, H. That is what he says, my lord, on oath.
Ridiculous.
And, my lord, two more pages.
Which page?
Page, my lord, 30, paragraph 16. And one more page, my lord, page 32, paragraphs 20 and 21.
Yes.
My lord, kindly take the trouble to have a look at the reply once. My lord, one more document I must show.
Yes.
My lord, page 37 of my reply.
Hmm.
My lord, this was in connection with the previous contempt proceeding, which my lord, ultimately we withdrew. My lord, this was there scanned there.
What is that?
My lord, paragraph 2. Page 37 of my reply, my lord.
Yes.
Paragraph 2. My lord, the order passed on 5th of February 2025.
Yes.
In the my lord, previous contempt proceeding,
This is your
paragraph.
version. Para 2 is your version, not there. Petitioner.
Wait a show. A submission was made to this court on behalf of the alleged contemner that the alleged contemner would comply with.
Appearing for the petitioner.
Yes, my lord, I say that they submit.
It's your submission about their submission.
Yes. And then, my lord,
their submission. Let us see that.
Next page, my lord, paragraph 8.
Yes. Para 5.
Yes. Specifically. It is in the specific relief act.
Yes, they agree that that submission was made. Para 2 submission.
Yes. Yes.
Yes. Anything else?
Now, my lord, specific relief act, my lord, this, my lord, we anticipate a defense from them that, my lord, no injunction can stop them from, my lord, proceeding, my lord, in a court of law. My lord, that will apply when, my lord, it comes to a superior court or, my lord, a court of, my lord, coordinate jurisdiction. But, my lord, a higher court, superior court, my lord, can pass an order of injunction directly.
They have not passed an order of injunction restraining them.
My lord, yes. So, my lord, so far as proceedings before the learned, my lord, trial courts, subordinate court, if I may say so, my lord, are concerned, my lord, this applies. Specific relief act is not a bar there.
Now, in a defense taken in a litigation, Mr. Banerjee, there is no, I mean, but that's on defamation and other things. This was a specific order; they cannot give out that. Let us see that
And
order.
they say, my lord, they have done wrong.
Let us see that order once more. Just that order was at page, the trial court order.
102
130
of our opposition.
129 minute of our application. 128 of our application.
130 is the order.
Yes, ordering portion. On 29 minute, the ordering portion starts.
Very, very. Yes.
This, Mr. Mojumdar, my lord.
Yes, Mr. Mujumdar, you want to add? Very. Yes.
No, one thing is that I was led by Mr. Shoikot Basu, who is out of station. On this point, section 41. He took the point of section 41, subsection 1. And
what does it say, reader?
Injunction cannot be granted to restrain a person from prosecuting a judicial proceeding pending at the institution of the suit in which the injunction is sought, unless such restraint is necessary to prevent multiplicity of proceedings. He was ready with a number of judgments, my lord. He has gone out of station.
Specifically একটা দিন শুনতে হবে তো উপরে রয়েছে একদম লাল বইটা ব্যাস ওটা জজ সাহেবকে ওই the suit where you have taken out this application that was pending at that point of time when the order was passed. Are we looking at the merit of our order or the trial court's order?
Not that.
This will be at best an argument regarding the merit of the order, merit of our order and the trial court's order. But you are on contempt. This is not a challenge against that order. Suppose that order was erroneous in law. Then also you are bound by the order unless it's set aside by some higher forum. So you have taken a plea that there was no injunction restraining you. You are citing section 41, but your defense in your opposition is that we did not restrain you from proceeding. Please. Your defense in the opposition is that there was no restraint on you to participate in proceedings. Aren't these contradictory? You say I state that none of the impugned orders have restrained me from initiating or contesting or participating in any legal proceeding. If you state that, then how does this lie? These are contradictory arguments you are making.
My lord, Mr. Basu will come back.
No, you go to jail and then Mr. Basu will come. Sorry, no. You are issuing a rule of contempt.
No, my lord, kindly.
What is your defense, sir? Mr. Basu is not a defense.
No,
and this bench does not sit every day.
No.
We published the list yesterday. That's the reason.
No, Mr. Basu.
Mr. Basu, forget Mr. Basu. You argue, you make your own arguments. You are on contempt. You don't have the luxury of asking for time, please. And here you have used your opposition. Contempt, the contemptation pleadings are over. Now it only remains for us to decide whether it's a contempt. We find it clear.
No,
Contempt.
It is our case that
you consciously filed an application for addition of yourself to a suit.
That was on the advice of my advocate, my lord. That's why I.
What advice of your advocate? You have taken a defense that you have taken an alternative defense and you were not prevented from participating in any proceeding. This was also on the advice. Everything was no. Sorry,
No,
you are sorry, sir. You are represented by counsel before this court.
Yes.
Then, if you want, we can issue a rule of contempt against you also. If it was on your advice, we are immediately issuing a rule against you. If you say it's your advice, we are issuing a rule against you. We don't hesitate to do that, sir. If you are in contempt, if I am in contempt, I will issue a rule.
No. My lord.
You are owning up that it's on your advice that he has done it.
It is not my advice.
Then
because these earlier advocates advised.
Please don't bypass the orders of the court in this manner. And you are encouraging people who are deliberately violating orders of sir. If you keep on speaking, your client will be behind the bars by the end of the day. I'm telling you, by the end of this day, if you go on speaking, first answer us. Is this a mode to violate order? On my advocate side, who was the advocate? Name him. We'll issue a rule of contempt. Please name the advocate. If your advocate's advice was this, we'll issue a rule of contempt against your advocate. Who was your advocate? Let us see. Let us see. Who represented him? Let us see. We'll issue a rule of contempt against him directly. Right? Yes, show us who represented order.
Mr. Sannal was there.
Let us see. Which was the page of the High Court's order? Order under
pages 30, 32, 20, and below 70.
No, High Court's order. Our Court's order.
Ajay Shankar Sannal was the advocate.
131 to 135.
Very. Now all the three advocates should go to jail then. Whose advice was it? Name the advocate here. You have not named the advocate.
Shankar Sannal was the advocate at that point.
There were three advocates: Shaunak Bhattacharya, Iftikhar Munshi, and Ajay Shankar Sannal. Why are you defending the others? You name in your application on affidavit which advocate advised you to do this.
My lord, at page 20, it has been stated that Ajay Shankar Sannal.
We'll give a notice to Mr. Ajay Kumar Sannal. And if you find that he disowns, he says that he did not give this. No. Yes, very well. Please serve a copy of this application on Mr. Ajay Shankar Sannal. We'll hear him. If you find that he says that he did not give the advice, you will be behind the bars. And we are issuing a rule of contempt, directing you to be personally present on the next date. Yes, we are issuing a rule and we are making it returnable next Friday. It will be deemed that the rule is served through you because you are present. You are representing the advocate, the contempt. A rule will be served on you, through you, for your client, through you. Please receive the rule when it is served to the office. From the affidavits in opposition, from the contempt pleadings in the contempt application, the affidavit in opposition and the affidavit in reply, we find that the order of the learned trial judge, whereby the contemner was restrained from proclaiming and/or projecting himself as the co-owner of the suit property in any manner till the disposal of the suit has been squarely violated by the contemner by taking out several applications before different courts of law, giving out that the contemner is the owner of the subject property. Full stop. Next para, the flimsy defense taken thereto in the affidavit in opposition is that the contemner is that no order of restraint was passed on the contemner from participating in any proceeding before any court of law. Push up. However, comma, in the same breath, comma, learned counsel for the contemner argues that by virtue of the bar under section 41 within bracket small a of the Specific Relief Act 1963, comma, no person can be restrained by an order of injunction from prosecuting a judicial proceeding pending at the institution of the suit in which the injunction is sought, comma, unless such restraint is necessary to prevent a multiplicity of proceedings. Full stop. Apart from such contradictory stand, comma, in the on the one hand, arguing that no restraint order regarding participation in proceedings was passed, and on the other, that the court cannot pass such an injunction order, comma, the contemner sets up a plea that being a layman, comma, he was guided by his advocate and filed an application under Order 1 Rule 10 of the Code of Civil Procedure in connection with a suit, comma, claiming himself to be the owner of the property, comma, on the advice of his learned advocate, comma, Mr. Ajay Shankar Sannal. Full stop. Next para. Apart from the first argument being untenable, comma, since it is not the merits of the order under contempt over which we are sitting, but as to whether there is any violation of such order, comma, since a categorical allegation has been made on the erstwhile learned advocate for the contemner by name, comma, for the sake of judicial propriety, comma, the said learned advocate is required to be given an opportunity to explain himself in that regard. Full stop. Next para. Accordingly, a copy of the contempt application shall be served by the learned advocate for the contemner on the said advocate, learned advocate, Mr. Ajay Shankar Sannal, comma, along with a copy, a server copy of this order. Full stop. Next para. Mr. Sannal shall be present on the returnable date to explain himself on the allegation, explain his stand on the allegation made, comma, particularly in clause small o of paragraph number 2 of the affidavit in opposition to the contempt application. Full stop. Next para. That apart, comma, this court is of the opinion that the contemner is admittedly guilty of contempt of the order of this court, and it prima facie transfers that the contemner seeks to shift the blame on his advocate. Full stop. Accordingly, since a case of contempt of the order of this court has been made out, comma, a rule to issue calling upon the alleged contemner to show cause as to why the contemner shall not be punished in terms of the prayers made in the contempt application by giving himself out to be the owner of the property in gross contravention of the order under contempt dated December 9, 2024. Full stop. Next para. The rule shall be made returnable on টোয়েন্টি 11 থাকছো না 25th নাকি 25th থাকছো না তারপরের উইকে পরপর তো ছুটি there is no Friday before 9th October when both of us will be available. Justice Bhattacharya will be in circuit the week after. Next Friday is a holiday. No, next Friday is a 4th September. Yes, yes, yes. Janmashtami, can't read. 11th September. 18th. তুমি 11th এ থাকছো না নাকি? 11th আর 18th 25th এ তাহলে রাখো।
18th এ থাকছি।
তুমি তো জলপাইগুড়ি যাচ্ছ। 31st August থেকে থাকছো না।
31st August থেকে 11th September.
তাহলে 18th September.
18th.
On September 18, 2026, full-stop, the rule shall be served personally on the contemner as well as through the learned advocate appearing for the contemner in the contempt application. Who shall receive it on his behalf? Give the full name.
Rasin Singh. 14 Rasin Singh, Advocate Rasin Singh.
Namely,
room number.
Mr. Rashin.
RASIN.
Give on a slip of paper, write it, and give the bar association number. Such and such, sitting at bar association room number such and such, which shall also be deemed to be a proper service of the rule on the contemner. At 2 PM বলেছে কি কোথাও ওই ডেটে at 2 PM এটা 2 PM রিটার্নেবল থাকবে ওই ডেটে একটু নোট করে রাখবেন রেগুলার কোর্ট অফিসারকে বলে দেবেন ডায়েরিতে আজকে লিখে রাখুন মিস না হয় যে কোনোভাবে থ্যাংক ইউ এটা নিয়ে Yes, next.
Number 9.
In this,
yes, you are for the
I am
petition.
for the petition.
What is the nature of
first order as pronounced by the Honorable Chief Justice is at page 25. Page 25.
ওইটা তুমি আছো বলে মনে আছে বলে গাইস তোমার লেগেছে How was it violated according to you?
Demolition order as pronounced by the trial court below was not acted upon. Now they persistently they are taking the plea that on non-availability of the force as well as equipment in their hands. Though in that order, the Honorable Justice was pleased to pronounce that the 8 weeks time was given to them.
Please show us that portion.
That is at page 47. That is at page 47 subsequently.
47?
47.
Contempt application? Acha, 47.
47. In paragraph 5, your lordship will be pleased to find that accordingly the time for compliance of the order dated January 4, 24, that was the original order,
yes,
was extended by a period of 8 weeks therefrom, which ended in 4th of May likely. Even after that,
they have not yet demolished the construction.
No action has been taken. That plea is being persistently being taken, the non-availability of equipment, as well as what is that other one in respect of the demolition, the other course of action, non-availability and equipment, and as well as police force. There's a specific direction.
What do you say?
First of all, I find out the subsequent order, this contempt petition was disposed of.
This contempt was disposed of?
Yes.
Have you got that order?
Well, 616, this is the case also, 616.
Where do you find it? Which page?
I'm sorry, man, I'm sorry. 616 P, I'm sorry. 1938. No, I'm extremely sorry. But the contempt application, which was filed in the earlier occasion, that was disposed of. The court specifically directed the order dated 4th of January to be acted upon. While disposing of that contempt matter, number 938/2024. Five, item number 5, clause 5, you also can see, my lord.
Yes.
The time for compliance of the order dated 4th January 2024 is extended by a period of 8 weeks from the date of receipt of the server copy of the order.
That content was disposed of with a direction on the understanding given by you that you will comply. The time was extended.
4th January 2024, he has done, my lord, first of all, neither in the prayer portion nor in the, my lord, the hostage, the act of contempt he has not explained. Be that as it may, yours can see 4th of January, the order, my lord, speaks of that, my lord, stopping of the unauthorized construction. And police was directed to look into it.
No, not only that, demolition. Because Justice, the Chief Justice's bench with
4th January, that is not the order.
4th March order is under contempt here. This contempt application relates to 4th March order, Mr. Ghosh.
The contempt prayer, checking out, if I am not wrong, my lord.
Second order eloquently reflects the violation or the non-compliance of the order, the first order of 4/1/24.
Please don't disturb him.
You can see at page 22.
Yes.
Here in the writ petition, contempt petition.
Yes, but you are still in contempt of the first order also. Even if a contempt
4th January order, this stopping of the construction, that has been done. Now the building has been constructed, we inspected. The process has been undertaken for demolition. The process means, my lord, to conclude the proceedings. The proceeding had already been concluded in each of the cases. Now, after the order being passed, my lord, we find that all the buildings, my lord, the parcels are in occupation. When the parcels are in occupation, my lord, according to our law and also police obligation, that we intimate to the police to get the premises vacated.
Mr. Ghosh, you file an affidavit and disclose all this.
Fine.
We are giving you a time.
Fine.
Let them disclose, you file a reply, and if you find still there is a contempt, then no.
Regarding compliance of the earlier.
Because there are several defenses taken by Mr. Ghosh, so let him. But there is Mr. Ghosh is right in saying that there is a discrepancy in your cause title and your prayer portion. First of all, in the cause title, you say the solemn order dated March 4th. It's a violation of that. And in your prayer portion, you refer to 4th January order. We can't reconcile the two. See the prayer portion, page 22. It continues to page 2. All the allegations are on 4th of January. On that count, you had already filed a contempt which was disposed of.
Yes.
So, you do whatever you have to do. We can give you leave to amend this prayer portion.
Subject to your lordship.
And you should also reflect as to what is the act of contempt. Mr. Ghosh is absolutely right on that also. Because our rules provide that in the cause title as well as the, not only our rules, there are several judgments, cause title as well as the prayer portion, you have to say how they have, what is the contributions act. Yes, by not doing this or doing that. Granting you, yes.
Nowadays, my lord,
nobody follows.
Tell them it is sin, my lord. But we are going on saying before the court that is the truth should be meticulously followed.
No, absolutely. You are right. You are right. Contempt is a serious jurisdiction. Right. You are right. You are right. Although court can so much to take into account by taking.
That's all.
But when you file an application, yes, you are right. We are granting the leave, and you please just you make the necessary corrections during the course of the day. And you will also hand over an amended copy to Mr. Ghosh so that he can have an opposition on that.
I may also submit, my lord, the contemnants which were implemented at that point of time,
they are no longer.
They are not in position.
Oh, then you have to inform them about the.
I will inform them because 2 is there, but 1 and 3 is not there.
So, Mr. Ghosh will record that also, and we will request you, whoever is your advocate on record, to inform him in writing as to what the present income. Do that within the by Monday. Do that. Today's Friday. So over the weekend, take instruction, and Monday by the end of the day, and we'll grant you time till Tuesday. Information only that, not the opposition.
I understand.
The petitioner alleges that in violation of the order dated March 4, 2025, directing demolition of unauthorized constructions, the alleged contemners have not yet carried out such demolition process. Full stop, next para. Learned counsel appearing for the alleged contemners submits that the alleged container numbers the persons named as alleged container numbers 1 and 3 have since are no longer in their office, and as such necessary amendments to the contempt application ought to be effected on such count. Full stop. Next para. Learned counsel for the alleged containers also points out that the prayer portion as well as the cause title of the contempt application is not in form, as the exact act of alleged violation has not been specifically enumerated therein. Full stop. Learned counsel further submits that a previous contempt application bearing CPA 938 of 2024, arising out of the order dated January 4, 2024, was previously disposed of, whereas in the prayer portion, it has been alleged that the alleged containers are in contempt thereof. Full stop. It is submitted that such discrepancies hit at the root of the contempt application. Full stop. Next para. On the prayer of learned counsel for the petitioners, we grant leave to the learned advocate on record for the petitioner to carry out the necessary rectifications to the cause title and the prayer portion of the contempt application by bringing the same in consonance with the provisions of the governing rules and the provisions of law, as well as to the effect that the violation of the order dated March 4, 2024 is 2025 is under consideration. Full stop. Next para. Such amendment shall be carried out during the course of the day, and a copy of the amended contempt application shall be handed over to Mr. Ghosh. Who is your advocate on record, Mr. Ghosh?
Shapon Kumar Devnath.
You hand it over to Mr. Shapon Kumar Devnath, the learned advocate appearing for the advocate on record appearing for the alleged contemners by August 24, 2020, by August 24, 2026, by Monday, hand over. So next para, the learned advocate on record for the alleged contemners shall also communicate in writing to his counterpart appearing for the petitioner the names and particulars of the present incumbents in the posts of alleged container numbers 1 and 3. Further leave is granted to the learned advocate for the alleged for the petitioner to carry out necessary rectification in that regard to the cause title of the contempt application. না যেটা কপি সার্ভ করতে বললাম না সেটা by August 28, 2026, আর যেটা বললাম যে অ্যাডভোকেট অন রেকর্ড কমিউনিকেট ইন রাইটিং যেটা বললাম সেটা by August 25, 2026. Mr. Ghosh, you will communicate by August 25 and you have to incorporate that also, and yes, by 20. Affidavit in opposition, if any, shall be filed to the contempt application by the alleged contemners, including the newly implemented contemners, এটা last including the alleged contemners. Within how much time do you need, Mr. Ghosh? Fortnight? 28. Fortnight after that? 2 weeks after that? You are there, Mr. Ghosh. Fortnight is sufficient. You exert your influence. Yes, you are as long in the panel as the existence of the corporation almost. What? We won't say that. No, we hope not. We hope not, because we want quality assistance. Anyway, affidavit shall be filed within September 18, 2026. Full stop. Reply thereto, if any, shall be filed within 1 week. Within September 25, 2026. Full stop. The matter shall next be listed when this bench reassembles thereafter.
I'm getting your lord.
Yes. মানে আমি দেখেছি অ্যাপ্লিকেশন কি নাম লিখে
Item number 10, your lordship appear for the petitioner.
Yes.
For the Howrah Jila Parishad led by Mr. Shivajyoti
Content.
My lord, I am appearing virtually, my lord, Shivajyoti Chakraborty for the Howrah Zilla Parishad, my lord, two of the contenders. my lord.
Right.
Lordship, may I be permitted to hand over the affidavit of service, your lordship?
My lord, my junior Ria Ghosh is having the compliance, my lord. May I be permitted to submit the same, my lord?
You have given copies to the other side?
No, lordship, the last order,
copies.
there was
Copies to
directions
the other
to
side.
there was directions to file the affidavit in opposition by 21st July 2026. It was never served.
No, you are directed to file affidavit in opposition. Where is that?
By
Yes, my
21st
lord.
July.
That is not ready, my lord. We
Had
have
to come
received
by
the
way of-
compliance.
No, this
My
had
lord,
to come by way of this had to come by way of an affidavit, Mr. Chakraborty.
Yes, my lord. I'm extremely sorry, my lord. I apologize, my lord. I require, my lord, little more time, my lord. A week's time, my lord. I'll bring it or bring the facts
It is
by your
not
affidavit in
about- it is-
opposition.
Ms. Ghosh, have they?
Lordship, it is not about the one respondent. Lordship, it is a 2014 order.
No, have you got a copy of this compliance?
No, they have not served.
Give a copy immediately.
Lordship,
And
there is no compliance. Lordship, may kindly bears with me for 1 minute.
Yes.
Lordship, the writ petition, Lordship, pursuant to the order which was passed, the first order, thereafter an appeal preferred, we have preferred a contempt, thereafter an order of merger, and finally, your Lordship, there is the order against which we have come before this honorable court, volume 1 of the CPAN 2056, 2025. Your Lordship very kindly takes the first order.
Which page?
Page 72, it is starting.
What is the ordering portion?
Lordship, page 72, these are the respondents. Lordship, page 75 once. Lordship may very kindly takes page 75.
Yes.
The second paragraph, the land. 1 bigha, 11 kata, 3 chitaks and such. Now, Lordship, I'll straight away go to the ordering portion. That is page 97. The matter was heard at length, finally decided, page 97, last paragraph.
Yes.
Accordingly, the writ petition is allowed with the direction upon the respondent authorities to remove the encroachers from the land of the petitioners and deliver back the peaceful possession to the writ petitioners within 6 months from the date of communication of the order, and to find a suitable place and or a plot of land belonging to the state government and or its organs to rehabilitate the occupants of the writ petitioner's property. Full stop. The cost of such rehabilitation is to be borne out by the state authorities, including Zilla Parishad and Panchayat. My learned friend is representing Zilla Parishad. All the concerned respondents are restrained from issuing any sort of documents and or creating any right in favor of the occupants who are all unauthorizedly and illegally rehabilitated upon the private land of the petitioner, for which the state authorities and its instrumentalities are instrumental. This court has come to a definite conclusion that the Block Land and Land Reforms Officer has made a wrong statement, deliberately and intentionally, affirming affidavits before this court as true to her knowledge. The averments are not supported by any relevant documents. For this reason, the concerned Block and Land Reforms Officer is punished by awarding cost of rupees 10,000, and the District Land and Land Reforms Officer is directed to deduct the said amount from the salary of the Block Land and Land Reforms Officer in the month of May 2014 and to pay the amount to the writ petitioners. Service book of the said Block and Block Reforms Officer would record such punishment.
This
Thereafter,
is the learned single judge's order.
this was the learned single judge.
Affirmed by the appellate bench.
Lordship, it was modified by this honorable court. An appeal was preferred.
Yes.
Coming to the appeal, and the order passed. Then the appeal was preferred. We had preferred a contempt application, and in the appeal order, in the order passed by the honorable appellate court, which is volume 2, page
Anyway, a copy is
172.
there at the beginning of.
Yes, page 172.
So we come.
10,000 was
Oh, that was.
10,000 was to be paid, The ordering portion is at page 188.
Para 46.
Para 46. 10,000 rupees was paid, but the remaining order was upheld. So therefore, the order remains that possession has to be handed over. Para 46 and 47.
So cost 10,000 to be deducted from her. This was affirmed.
Affirmed.
And the merits, the demolition and all were affirmed. Only that remarks in the service book that
was removed. Your Honorable.
So the rest remains.
Rest remains.
Right.
Now we have again gone back to the contempt, which was before the Honorable Single Judge, page 190.
Yes.
Page 190, the contempt was heard, and since the order was modified, so there was a merger, and we have again preferred this present contempt. We have preferred this present contempt before this Honorable Division Bench, Your Lordship. Now, Your Lordship, the direction.
How they have complied with.
No compliance, Your Lordship. We are not handed over the
her.
land.
No extra copy.
My
Your
lord.
copy you're handing over.
Lordship, may I,
My lord, one humble submission, my lord, before my learned senior is making submission. Out of the contemnants, I am only representing the Howrah Zilla Parishad. About the state, represented by separate advocate. Now, my lord, what has happened is that the Sabhadipati has resigned 1 month back. The hearing officer has also changed, my lord, but I will file it in the form of an affidavit. But this is my difficulty, my lord. And compliance with regard to what my learned senior has read out just now, rehabilitation, that already we have done. But it was supposed to be placed in the form of an affidavit in opposition that I am seeking 7 days time, my lord. I'll place it in the form of in opposition only, my lord. I compliance affidavit, I'll place it, my lord.
The removal has been done. Position has been
My lord, that the state will say, my lord.
Who was substituted
Lordship,
the state?
Lordship, there was directions. This is the appeal, Your Lordship. Let me clarify from the appeal which was carried on by state. Who are the appellants? The appellants are the district magistrate and collector himself, the superintendent of police,
yes,
the district land and land defense officer, the block development officer, the block land and land defense officer. They have themselves preferred the appeal. We are not aggrieved by the stand taken by Howrah Zilla Parishad. They say we have complied. Your Lordship, subject to correction, what was the nature of compliance? The nature of compliance was hand over me my property, rehabilitate.
So you don't have any grievance as such against the Howrah Zilla?
Lordship, we have no grievance against any respondent specific. The only direction was to hand over by the respondent authorities, whoever it is, block land reforms or Zilla Parishad or DM or they all together. We cannot segregate.
I got 3,50,000 has already been paid. 10 families we have rehabilitated. We have already paid the amount also. Now it is for the state to make
Yes, Your Lordship. I think what my learned friend is pointing out, it is not only the responsibility of the Zilla Parishad alone. It is the DM, the block land and land affairs officer who was adequately directed to hand over possession. The rehabilitation was of 2014. Be that as it may, they preferred an appeal. Even thereafter, the order is upheld.
Zilla Parishad is only responsible. Container number 1.
1.
2 and 3. 2 and 3. You have served.
We have served.
Lordship, I am representing the others content.
What about your opposition?
Led by Mr. Senior.
Whatever.
Lordship, the occupants came before single bench, Lordship, and there is a stay, Lordship. Kindly see the matter.
You are directed to file an affidavit in opposition, ma'am. Where is
Lordship,
that?
We don't got the brief just 2 days before, Lordship. We are appearing in first time, Lordship. Lordship, and the occupants came before Honorable Single Bench. And
no, you were served on the last occasion also. Previously also you were served.
Lordship, but we don't got the brief 2 days before, Lordship.
Your clients will come directly. No, if you have got the brief, let your clients come and explain.
Lordship, kindly acknowledgement, Lordship.
No, we had recorded in sorry, ma'am. We had recorded in an order dated 30th of June 2026.
Lordship.
That it is noted that alleged containers 2 and 3 are not present and are represented today. We had recorded previously that they had been served. In the event the said alleged containers are not present or represented and or do not file their affidavits in opposition by the returnable date, appropriate orders and rules may be passed / issued against the absentee contemners on the returnable date. The moment you got the brief last night, this morning, a few hours back, you should have checked up the website as to what order was passed last.
May I kindly, Lordship, occupants came before Honorable Single Bench, Lordship, and there is a direction for no coercive steps shall be taken. On that day, District Judge, District Magistrate initiated to demolish their house and rehabilitate them. On that day, they came before Lordship, and since today, since last week, Lordship, we mentioned 3 times, Lordship, before Honorable Single Bench, but as per court officer said that the total record is missing till date, Lordship.
What does
File
this
is not
matter have to
traced.
do with the present?
69
Sorry, ma'am. What does this matter has to do with the present matter?
Lordship, they are occupants, Lordship. Actually, they are occupants in this land, Lordship.
So what prevented you from putting this on oath? Do that. File an affidavit in opposition, put all these on record.
Lordship, herein, Lordship, Mr. What I'm able to just observe, Mr. Shobhoshaji Chatterjee, if I've correctly observed, he has tried to intervene when your Lordship has not allowed his intervention. Now, this is the manner where the occupants, what is a coercive action? They are asked to rehabilitate. They are not said that coercive actions means they are not thrown on the street.
Lordship,
They are not thrown on the street. What is the coercive steps? They are asked to rehabilitate. Does rehabilitation doesn't mean coercion?
Sorry, not only that. Have you seen this order? Do you have another copy of this order?
Yes, Lordship.
Have you seen what order has been passed here? You don't have another copy of this order. We are reading out for you what you have handed over right now.
Lordship,
we are reading out to you what you have handed over just now.
Lordship.
This order records Mr. Chatterjee, learned advocate appearing for the petitioner, submits that there is urgency involved in this matter.
Yes,
Mr. Bhattacharjee, learned advocate appearing for the state, which is one of the contemners here, seeks time to take instructions in this matter. Let this matter appear on such and such. Mr. Bhattacharjee, learned, he was the senior counsel, standing counsel. Mr. Bhattacharjee assures the court that no coercive steps shall be taken till the next date of this is active. Either you speak or we speak.
I apologize.
This amounts to aggravated contempt because this is not an order of the court restraining or saying that you won't take any coercive action. The state has given this assurance to the court in the teeth of our order and the order of the learned single judge that you have to immediately rehabilitate them. I mean, you have to remove them and give them back possession. So if you give this assurance to the court, contrary to our order and the order of the learned single judge, you are in aggravated contempt, ma'am.
Lordship,
we don't have issue rule.
Lordship, we don't have the actual facts or actual
problem.
instruction at that time.
That's your problem. Advocates are not engaged. No advocates have instructions. That's not our problem. This is contempt. And in contempt, you know when to be serious and when not to. Your client should know. They will know now.
Lordship, alleged contempt are ready to comply the order, Lordship.
Now it's too late, sir. Sorry, too late. In the time we are issuing rule, let them come. Let them come. Let them come and explain.
Lordship, kindly.
Learned counsel for the petitioner. No, affidavit of service filed to be kept on record. Full stop. Learned counsel appearing for alleged container number 1, the Shobhatipati of the Howrah Zilla Parishad hands over a purported compliance report as to rehabilitation steps having been taken for rehabilitation of the unlawful occupants who are on the subject property at the juncture when the order under contempt was passed. Full stop, the same is kept on record. Full stop. The learned advocate appearing for the alleged container number 1 shall serve a copy of the compliance report to the learned advocate on record for the petitioner during the course of the day. Full stop, on the prayer of learned counsel for the alleged container number 1, the time for filing affidavit in opposition to the contempt application by the said alleged contemner is extended for a week from date. Full stop, next para, learned counsel appearing for the alleged container number 2. Ma'am, you are for 2.
Lordship.
Not 3.
2 and 3. 2 and 3.
For alleged container numbers 2 and 3, hands over a server copy of an order dated June 16, 2026, passed in WPA 6951 of 2025, and submits that the said order was passed on a writ petition filed by the unauthorized occupants of the property. Full stop. Next para, it is sought to be impressed upon the court that by dint of the said order, the alleged container numbers 2 and 3 have been restrained from taking any coercive steps against the unlawful occupants. Full stop. Next para, it may be noted here that by the order under contempt, the alleged containers had been directed to remove such unauthorized occupants initially within 6 months and thereafter the extended time. Full stop. Next para. However, in the from the order dated June 16, 2026, a copy of which is handed over today, we find no such direction, no such restraint order being passed by the court in any manner whatsoever. Full stop. Rather, learned senior standing counsel, appearing for the state, had assured the learned single judge that no coercive steps shall be taken till the next date of hearing, which evidently is an aggravated act of contempt on the part of the alleged container numbers 2 and 3, since not only did the state did not apprise the learned single judge as to the subsistence of the order now under contempt, but granted assurance to the court that no coercive steps shall be taken against the unlawful occupants, which in the teeth of the order of this court and in gross contravention of such order. Full stop. Such aggravated contempt is taken note of. Full stop. Next para. In any event, since the alleged container numbers 2 and 3 have not filed any affidavit in opposition as yet, on the prayer of learned counsel appearing for the said alleged containers, for the ends of justice, a last chance being given for filing such opposition. Full stop. The time for filing affidavit in opposition for the alleged container numbers 2 and 3 is also extended, for a week from date. Full stop. Next para. Advance copies of the oppositions shall be filed on the learned advocate and record, shall served on the learned advocate and record for the petitioners. Full stop. Next para. Reply, if any, shall be replies thereto, if any, shall be filed by the petitioner within a week thereafter. Full stop. The matter shall next be listed as and when this bench next reassembles. No, it shall next be listed on September 18, 2026. You please put whatever you have to put in your affidavit in opposition. And 1 week. You also
My lord. Grateful, my lord.
Those have to be separate oppositions for both the contemners. Otherwise, that will be another act of contempt. You both filed together. Yes. Next. একটা কোথায় affidavit of service filed today kept on record. প্রথমে বোধহয় বলেছি।
Lordship, indicating rule is returnable on any
rule we are not issuing now.
Lordship.
Let them have an opportunity.
Lordship, grateful.
Initially thought we'd issue a rule.
Lordship.
Let us have that opposition.
Lordship, will come.
That will give them further time to comply with this order.
Lordship. Lordship, may I only pray for a time on the next date your Lordship is keeping?
We have kept it on September 18th.
Lordship, any time may be fixed or it will be taken up in course?
We don't know when we will be sitting at maybe post recess, maybe.
Lordship.
Not sure. Depending on how many matters there are in the original site.
Because in
how many matters there are in a
last matter was kept at 2 p.m. Item 8. If any time may be fixed.
No, whenever maybe then 2.
Grateful, my lord.
Yes, next. 11, 12.
My lord, we have already.
My lord, I am appearing for the petitioner, my lord. The order has been complied with by the added respondent.
That's why you are so happy there.
Yes. My lord,
making comments about Mr. Ghosh and all.
Oh, my lord. The only thing that I possess is my smile, my lord. Nothing else, my lord.
Great. Please retain that.
My lord, the affidavit of service may be kept in record. We have served them.
Affidavit of service filed to be kept on record. Full stop. Learned counsel for the alleged contemner submits that the order of this court has been complied with, which is corroborated by learned counsel for the petitioner. Full stop. A document in that regard is filed in court and kept on record. Full stop. In such view of the matter, CPN 13 of 2026, is disposed of as infructuous, no address to cost. Thank you.
Deeply obliged.
Thank you.
Lord, I appear for the petition. May I, my lord, file the affidavit of service. Lord, during pendency of this, my lord, contempt application, Lord, some order has been passed by the contemptor, but actually, my lord, the order passed by your lordship has not been complied in its true meaning and effectual. Lordship kindly have a look to the, my lord, order under contempt, my lord, at page 35.
হ্যাঁ এই জিপি আছে আছে ইউ ওয়ান্ট টু হিয়ার
Where is the order of the learned single judge?
My lord, learned single judge
Will
order.
we affirm that?
My lord, that is not annexed to the contempt application.
That is what we affirm. It's a content virtually of that which has merged in our order.
My lord, only with regard to, my lord, page paragraph 10, my lord, of your lordship's order. Paragraph 10.
Conversion application is filed. Conversion shall come. You have filed a conversion.
My lord. My lord.
They have not considered according
My
to.
lord, during pendency of this, my lord, contempt application, without hearing us, my lord, to evade the contempt proceeding, my lord, they have rejected our application.
They always do that. But if there an order is passed, then it's a compliance of this order.
My lord, kindly have a look to the order, my lord. Hearing if necessary. My lord,
No, Mr. Chok, we have said that hearing is necessary.
my lord, if necessary.
We'll come to you.
My lord, paragraph 10, my lord, by giving an opportunity of hearing to the petitioner at the
Necessary by giving an
my
opportunity.
lord, in this order, my lord, they have not stated that hearing is not necessary. Logically, have a look to the order, my lord.
You are going to hand over that only, this order.
কবে দাদা 10/7/26 yes
Nothing has been, my lord, considered. My lord, it is a case of, my lord, wetland. We have filed several documents showing that our land is not, my lord, within the ambit of the, my lord, wetland. But to evade this contempt proceeding, my lord, all of a sudden this order has been passed.
They have given reasons, Mr. Chakraborty. There's an IT hub in close vicinity and wetlands categorized as wetlands of international importance under Ramsar
My lord,
Convention.
can appreciate, my lord.
There are some reasons we challenge this. There is,
My lord,
this is a fresh cause of action.
my lord, no hearing has been given because, my lord, we have a case, my lord.
Not mandated as per our order if necessary, because they have to take a decision. Law does not say that a hearing has mandatorily to be given. We carved into our order an opportunity of hearing if they feel that there is something against you or they want a clarification, then hearing could have been given.
No, my lord.
But is there a statutory mandate, Mr. Chakraborty? Probably
No.
there is a statutory mandate of giving any
No,
hearing.
my lord, why, my lord, why, my lord, respect to submission before lordship, my lord.
This-
Why
you can
this order
challenge
was,
this. You can challenge this.
my lord, why this order was passed by your lordships, my lord, we challenge.
That we don't even know why we passed this order.
My lord, this is, my lord, the stated, my lord, in the body of the, my lord, order. My lord, if land has been, my lord, categorized as, my lord, wetland. My lord, we did not challenge the virus of that act. We only, my lord, challenged the inclusion
By
of
this order, Mr. Chakraborty, we only gave you liberty to file an application for
conversion.
If you file that, they'll consider and dispose of the same, if necessary, by giving an opportunity of hearing.
My lord.
Now they have passed reasoned order, they have decided the same, they have not given opportunity of hearing to you.
My lord.
It was not deemed by them to be necessary. It was not required by them to be mentioned in the order to be necessary. Because there is no statutory right of hearing which you have.
My lord.
We carved that into this if they feel it necessary.
My lord.
You challenge this, we'll give it open for you to challenge, which is in any event open to you to challenge. Challenge this via fresh writ. The present contempt application has been filed on the allegation that in contravention of the direction of the order dated. This is the date of the order, it's smudged.
18/11/2020.
November 18, 2025, passed in FMA 1450 of 2025 with Can 1 of 2025, the alleged contender had not decided the application for conversion filed by the petitioner in terms of the order of this court upon giving an opportunity of hearing to the petitioner. For sub next para, learned counsel for the petitioner hands over a copy of an order dated July 10, 2026 and submits that in order to avoid the penalty for contempt, the alleged contemptor has hurriedly passed such order without giving any opportunity of hearing to the petitioner. For sub next para, learned counsel for the alleged contemptor also cites the self-same order and submits that by way of a reasoned order, the application for conversion of the petitioner has been rejected. Which we find from the order dated July 10, 2026, that although only after filing of the contempt application, an order has been passed and a reasoned order has been passed while disposing of the application for conversion filed by the petitioner. Full stop. Next para, in paragraph number 10 of the order under contempt, we had directed that if an application for conversion is filed, the concerned authorities shall consider the same and decide on the same, with an additional rider that an opportunity of hearing shall be given to the petitioner within double inverted if necessary, double inverted close, full stop. Since there is no statutory requirement otherwise to mandatorily give a hearing to the applicants for conversion, by dint of our order, only if the alleged contender felt it necessary to give such opportunity of hearing, would it be appropriate for him to give such opportunity. Full stop. However, merely due to no opportunity of hearing being given to the petitioner, it cannot be said that the alleged contender is has violated the order of this court. যেখানে his বলেছে ওটা her হয়ে যাবে. Full stop. Next para. In any event, by dint of the reasoned order dated July 10, 2026, the order of this court has been substantially complied with. Full stop. The remedy of the petitioner against the said order, if any, lies in accordance with law by way of an independent challenge, and it is beyond the scope of this court, sitting in contempt jurisdiction, to enter into the legality and or veracity of the same. Full stop. Accordingly, CPAN 292 of 2026 is disposed of as infructuous by granting liberty to the petitioner to challenge the reasoned order dated July 10, 2026, if otherwise so entitled in law, before the by way of a properly constituted challenge. Full stop. No orders to cost. Great. Affidavit of service filed today could be kept on record.
My lord, in item 14.
Yes.
Item 14, I am appearing for the petitioner, my lord.
Yes.
Pursuant to my lord's direction on 29 June, service has been effected upon the contemptors.
The respondent led by Mr. Nilanjan Bhattacharya.
What is your defense to the contempt? Ms. Dwachiti, what is the nature of the contempt? Please just remind us.
My lord, there was a resumption order passed by the Vidhanagar Urban Land Development Department, my lord, and that has been set aside, and the respondents were directed to mutate the name of the petitioner, number 2, within a period of 2 months from the date of publication of the order.
They have not done that.
They have not done.
Yes, what is your defense?
My lord, we have filed a review application, my lord.
That is not a ground.
My lord, we have filed a review application.
You have
My
filed
lord, the review application has not been communicated to us. Not served anything.
Must have been filed after you get a copy of this contempt application. That's a way to avoid contempt. This is a technique you are developing, but what is the ground for it? Let us reject the review application right now. Move the review application. Is the review appearing today?
No, my lord.
Did you mention it?
No, my lord, I didn't mention.
Why?
My lord,
give the number on a slip of paper. Give a copy to them during the course of the day. We'll keep it. Ms. Rashidi will keep this along with the review application on the next day. We'll hear the review. Thereafter, depending on the outcome, we'll decide this.
My lord, and the letter service affidavit be kept on record.
Yes. Affidavit of service filed to be kept on record. Full stop. Next para. Learned counsel appearing for the alleged contemner submits that an application for review of the order under contempt has been filed in the meantime by the alleged contemners. Full stop. Next para. It transpires that the said application has been filed to avoid the punishment for contempt, comma, only after getting a notice of the contempt application. Full stop. Be that as it may, comma, since a review application has been filed, comma, for the ends of justice, comma, the same ought to be heard before the contempt application. Full stop. Accordingly, the alleged contemners shall serve a copy of the review application on the learned advocate record for the petitioner in the contempt application during the course of the day. Full stop. Next para. The review application bearing what is the number? Number
80/2026.
RVW.
RVW 80/2026.
80.
80, madam. 80.
RVW 80 of 2026 shall be listed along with CPAN 304 of 2026 on September 18, 2026. This much.
My lord, at 2 p.m., my lord. My lord is fixing the matters at 2 p.m.
Yes, we are not fixing a time, but the understanding is that it will be taken up after recess. 2 p.m. we
My
are
lord,
fixing.
and another liberty I will be praying for. If
Yes.
they serve us today and if there is an affidavit or opposition needed to be filed, my lord, I
Yeah,
will be at liberty to.
we will direct affidavits to be filed in connection with both the applications. After line add karo. Affidavits in opposition to the contempt application as well as the review application shall be filed within a week from date. Full stop. Replies thereto, if any, shall be filed within 1 week thereafter.
Okay.
That
I'm
applies to
grateful,
both the applications, review and contempt.
Fine.
Thank you. Yes. Next.
Standing counsel.
My lord, I appear on behalf of the petitioner.
15, yes.
My lord, I appear on behalf of the petitioner. This is an application by the wife.
Right.
My lord, kindly comes to my lord's order dated 12 November 2025 at page 12 of this application. My lord, paragraph 7. My lord, by this order, it was directed that the respondent husband to pay alimony at the rate of rupees 10,000 per month to the appellant by the 10th day of each current month.
Yes. What have they done? They have not paid anything?
My lord, they have paid, but they have been paying rupees 5,000 every month. I'm completing, my lord. Kindly comes to the prayer portion.
They've adjusted that.
Yes, my lord. The arrears are 30,000, but they have cleared 10,000 rupees. Only 20,000 rupees is pending. If they pay that, then it will
Pay
be
that
fine.
In total, Lordship,
will drop the contempt.
yesterday we also paid 10,000, but there are some difficulties on some time is required because the elder brother who was a pension holder used to pay the money for the brother. He's a 75 years old, doing nothing, staying as a caretaker in a flat. So some time is required, Lordship.
What is your age?
74. 74.
Your client's age is 74.
74. His brother was 82. He died, Lordship.
What is the wife's age?
Wife says, Lordship, 16 years lesser than the husband.
16 years?
It's more 62 or 70.
60 years, man.
60 years.
So she is also entitled to maintenance.
Yes,
on
I'm
account
paying,
of
Lordship,
age.
but the difficulty is, Lordship.
What can you do? You cannot arrest age.
No.
That is not a
He is
ground
not
for
doing
avoiding
anything.
alimony
I'm
orders.
paying some time, Lordship, because some time is required. We will continually as paying, Lordship.
Mr. Channel will permit you to file an affidavit of opposition within a week.
Yes, Lordship, disclosing all the.
We'll take it up on 18th of September and we'll record they'll file a reply within a week. We'll add an additional line that nothing in this order will prevent you from clearing of all the dues in the meantime. So that you can clear and purge the contempt and we can drop it.
Only,
Lord, they had
only
already
thing may I
charged.
play, Lordship, though it is not related with the contempt application, the divorce decree, Lordship, they have withdrawn the appeal. Now, in respect of the alimony, the appeal is, Lordship, pending. If you, Lordship, heard the matter, Lordship.
You are not paying alimony and we'll hear the matter.
We will pay, we will, Lordship, pay.
Sorry, it's well settled. If you don't pay, your appeal gets stalled.
No, it's their appeal. I
Very
will pay,
well.
Lordship, by the next sitting in your Lordship. So we'll
If
pay.
it was a suit, you could have decreed it for your non-payment.
Now,
anyway, clear it.
My lord, they had already filed an application for
No question
recalling
of
of
taking
the
the
order.
appeal. No question of taking up the appeal unless you clear the element. Sorry, yes.
They have already filed an application for recalling of this order, which was rejected by your lordship on
calling
24th
on the
March.
ground that we could not appear on the day of disposal. Because Lordship, the
counsel for the petitioner wife submits that in violation of the order of this court directing alimony to the tune of rupees 10,000 being paid along with arrears, comma, the respondent husband, the alleged contemner stroke husband, has only partially cleared off the dues of alimony. You are paying the current alimony.
current alimony,
Very
in total, Lordship, there is a due in accordance with
Question of
our
next para.
20,000.
Learned counsel for the alleged contemner submits that due to financial hardship, comma, the amount could not be, the total amount of dues could not be cleared off. However, comma, learned counsel for the alleged contemner further submits that the alleged contemner shall clear off the dues at the earliest. Next para. The alleged contemner is directed to file affidavit in opposition to the contempt application within a week from date. Reply thereto, if any, shall be filed within a week thereafter. It is made clear that nothing in this order shall preclude the alleged contemner to purge the contempt by clearing off all the dues of alimony as per our direction. In the meantime, needless to say, comma, the alleged contemner shall also go on paying the current alimony as already being paid per month. The matter shall next be listed for hearing on September 18, 2026.
May I request one thing, Lordship, because there is a difference of 5,000 according to my calculation and their calculation. Can they, Lordship, supply Lordship calculations as that?
That's not an issue.
Not order from the court, Lordship.
That's not an issue. You're too shy to ask her. Make that request directly.
No, my lord, here already.
Next.
Lordship, whatever will help us.
Yes. না এখন এখন কত হয় নরমাল কোর্সে? না না সিরিয়ালি দেখুন, ওদের তো বলেছি 3:20 নাগাদ মেনশন করতে যদি না নিতে। এখন আপনি সিরিয়ালি দেখুন।
16.
Yes.
Now, my lord,
Yes,
My lord, I beg to pay respondent.
so my lord, it was hard.
Mr. Banerjee,
My lord.
This is on the ground of irretrievable breakdown. Was it that?
My lord, that's
Remind us. Yes.
that's true, my lord. And now I'm making this fair for obvious reasons, because for more than near 20 years or more than, they are living separately.
You have challenged the divorce decree, but you are agreeable now to part ways, to separate.
My sons, an attempt was made for mediations. My lord was kind enough to send it to the mediators.
Failed.
Mediator tried it 11 years. One of them was a retired High Court judge, another patients. The my sons were also requested to come. They're grown up, they're doing this. So they say no. If my mother come, we'll leave this one. Because for these reasons,
Answer residing with you.
yes, all along. Not only that, my lord. My lord.
You said on the last occasion she had left the sons and all.
Yes.
So, Mr. Banerjee, if you are agreeable now to part ways, let us record a ground of on the ground of irretrievable breakdown, and we quote Rakesh Raman.
Yes.
Because otherwise, there cannot be a compromise decree in a.
No.
Oh, you can just withdraw the appeal then. That would suffice. They are already enjoying a divorce decree.
No, my lord. Actually, suit was filed by my client.
Oh, your divorce suit was dismissed.
Dismissed.
So then we'll record this irretrievable breakdown and pass it.
My lord, may kindly hear me, my lord, in meanwhile.
Yes, definitely.
This petition, my lord, was filed by the appellant, my lord, praying for divorce, my lord, on the ground of, my lord, cruelty. Now, my lord, a detailed and reasoned judgment has been delivered, my lord.
It's with cruelty.
Yes, my lord. And on the last occasion, my lord, my extreme senior, my lord, was, my lord, placing the judgment, my lord, and the point or the issue of irretrievable breakdown of marriage, my lord, it was also urged at the time of hearing, my lord. The learned trial judge, my lord, came to a conclusion, my lord, that if the exact sentence was, if the cruelty is at the doorstep of the petitioner, then it will be questionable if this my lord, page number 129 of the.
Says, I don't have any power under 148.
My
You
lord,
can make a chance. That means he was really in dilemma. She was really in dilemma.
After going to everything, she found that was the knowledge judge found. No, this is such a case. But kindly see the practical aspect. For the last more than 20 years, if not more, they are living separately. They have lost their
Number
youth and
126, my lord.
everything is gone.
My lord, there is a resolution. Well, page number 126.
Mr. Banerjee will take
My
it up
lord.
on the next occasion today because we are breaking up at 3:30 and
No problem, my lord, no problem.
Acha,
My lord, I am just praying, my lord, kindly hear me out, my lord. I'm
No, without hearing you.
My lord, I am opposing the appeal, my lord.
Very well, we'll hear you out. 24-25 was being mentioned in the
item 24 and 25. Your Lordship, we have mentioned this matter at 2 p.m. It was my lord's pleasure, my lord, to
both sides are there now before us.
right. We have it was upon notice, Your Lordship.
The other side was
Other
present.
side was there when the matter was
They
mentioned.
also agreed to the matter being taken up by the regular bench.
The learned
Because the other side
he was there.
24-25 একটা order record করো 24-25 টা board একবার দেখান upon being mentioned by both sides comma the matter is being taken out of turn full stop it transpires that the hearing had only commenced and as such the double inverted part heard double inverted clause marking in the matter be cancelled and the matter be placed in the list of the regular bench under the heading to be mentioned on August 24, 2026 for passing appropriate orders. Monday it will appear under the information before the regular.
So you cannot live together, my lord, for the use of it.
আচ্ছা এইটাতে একটা অর্ডার রেকর্ড করে 16 যেটা হলো মিস্টার ব্যানার্জি heard in part for further hearing on September 18, 2026 in your matter.
Yes. I'm grateful.
Yes, column.
Miss, my application, my lord, for
Mr. Chaturvedi, you are for the all the respondents. Oh, you're the state now. Yes.
state is, my lord, the only thing.
Well, yes. Not the private respondents.
No.
They are not represented. Private respondents. Well,
They are not here.
main grievance is against the state.
Yes.
There is no grievance, my lord. Grievance is against me. My lord, I have done a mistake. My lord, page 113 is my lord's order.
What is the mistake?
My lord, we said that, my lord, we...
The recall application?
Yes, my lord. My lord, our submission was that, my lord, we will not, my lord, prosecute with this, my lord, writ petition. We will, my lord, go for the statutory remedy.
Yes.
My lord, this matter pertains to, my lord, there was, my lord, an instruction given over phone by the...
Obviously, otherwise you would
Yes.
have.
Now, my lord, I just indicate, my lord, what has happened.
Mr. Mujumdar was also there.
Yes. Oh.
Yes. So it's his mistake, not your mistake.
My mistake.
Because owning up the mistake, so we are now you will say
it's my mistake.
So resolve that first. Whose mistake?
No.
It's an interpreter sort of situation. Yes.
May I just indicate that we don't want any material change in the order. What we are humbly praying before your lordship is that we will exhaust our statutory remedies if any remedy is available. Our deed is held because it is pending IGR. So we will pay the differential duty as determined, and as
why should this order be recalled? This only granted you. This was withdrawn, and we gave you liberty to approach the.
But we can take back the get the deed. The deed is pending registration.
Nothing in this order prevents you from doing that.
It prevents. Kindly make it clear. Otherwise, they will say another. It is pending, etc., etc. Then kindly indicate that.
What is nothing is pending?
Last order ta kothay? No. না ওই যে ওই সাপ্লিমেন্টারিটা দেখা যেটা হচ্ছে তোর এটা one kindly give me.
But there is a determination of market.
Yes. We will pay that. That is what I'm on. We want to pay that and get the deed.
You're acting as if you'll directly pay it to Mr. Chaudhary. You will pay that. We will pay that.
Well, kindly take page 106 of your lordship's this supplement application. This application.
Yes.
The lordship will find 106. This is a determination made by 47A. Under section 47 capital A.
You are challenging that.
I will challenge that. I will challenge that.
So in the interregnum, you want to pay it without prejudice to your rights to challenge.
That is all, and get the deed, my lord. Get the deed. The deed is pending IGR.
What do you say to that?
No, my lord. For that, my lord, the order need not be recalled because 47 capital A, lord, subsection 7, it says that upon determination, lord, once if a party, my lord, wishes, can pay the amount.
But that will be then they'll waive their right to challenge.
No, lord, 47B is already there. They can prefer the appeal before the appellate forum. They can seek the leave that they are seeking from my lord.
Madam, may I just
kindly take 47B,
kindly take.
Don't have this.
Kindly takes my book.
Yes, we'll just for the
47B, kindly, if your lordship kindly takes 47B, any concerned person aggrieved by an order passed under subsection 5 or subsection 8 of 47A, determining the market value may in the prescribed manner prefer an appeal to such appellate authority as may prescribe within such 60 days from the date of receipt of such order, or such further period as may be allowed by the said authority for the cause to be shown to his satisfaction. Where the subject to the rules, as may be prescribed, the appellate authority shall dispose of any appeal preferred before him under subsection 1 in the prescribed manner. Where the appellate authority modifies the amount of stamp duty determined under subsection 5 or subsection 8 of 47A, the modified amount of such stamp duty is higher than the stamp duty already paid by the concerned person. He shall pay interest at the rate specified in subsection 6 of section 47A.
Mr. Mojumdar, although it does not specifically provide for what you are asking for.
Yes, it does not.
But you can, we can give you leave that this does not.
I tell you, lordship, the procedure is like this.
We are no longer in season of the matter. We just.
May I just humble?
We leave to make this prayer before the appellate authority.
Appellate authority cannot get my deed released. The deed is with the registering authority.
No, if you prefer an appeal,
may I just
have the power
just couple of minutes of your lordship's precious time. This is not a conditional appeal that I pay X amount of the duty.
No.
This is the appeal without payment of duty. So the registration which is pending would remain pending so long as the appeal is kept pending.
If the law does not permit, how can I
we are undertaking, we will pay the deficit amount.
Why should it be recalled then? If you are intended,
I'm not recalling, I'm not praying for recalling, but what I am seeking humbly before your lordship is.
You would not record a single line on that, Mr.
If the submission, kindly record the submission made on behalf of the state that this will not be stand in my way of praying for release of the deed.
The state submits that only then.
Already submitted. It does not require any order. That is exactly what Mr. Chaturvedi submitted. No order is necessary.
No, if you are otherwise entitled in law to go and do it, why do you require a record?
May I just it is
Mr. Upadhyay is with you in this matter.
Yes. Mr. Upadhyay.
No order on this record. No, not because he is there. It must have been his brainchild.
I tell you, lordship, we are ready to pay the deficit. It's not that we are not paying the deficit.
If you are ready, if the law permits you, you go and do that and get the deed released subject to. Otherwise, Mr. Mujumdar, I won't carve out a right which is not there in the statute in a recall application.
Then, my lord, would your lordship, subject to lordship, would your lordship
I'll
let
record
it-
your submission.
kindly record my submission?
And I'll say that if you are entitled otherwise in law to do that,
yes,
nothing in this order prevents you from doing.
That's all. That's it.
Lord, kindly see Lord 47 capital A, subsection 7.
46, sorry?
47.
7A, 7.
7A, 7.
47A, 7.
Once there is a determination, Lord, nothing prevents them to get it registered upon making payment of that amount along with interest.
But I cannot prefer appeal.
Then he'll be precluded. Let us just check up where the
Now, Lord, they have to, Lord, if they are so advised, they would prefer an appeal and there, Lord, seek a leave that they want to take recourse to 47 capital A without prejudice to the rights and contentions pending in the appeal.
Well, let this submission be recorded. That's all. Well, let the submission made on behalf of the state be recorded. But that would even not invite.
It would seem advisory if it is recorded. Advisory to my adversary. I am only trying to assist your lordship. I am only trying to assist your lordship.
Between the state and citizen, there is no adversary.
Since a query fell from my lord, I am only as an officer of the court trying to assist your lordship that this is what the law permits. Now they have withdrawn. They say that they want to take recourse to the statutory remedy. So, and they, in any event, they are still today sticking to this decision in principle that they want to exhaust their statutory remedy. Once they take recourse to the statutory remedy, the statutory authority is not without any power to take recourse to 47 capital A subsection 7. If such leave is sought for and the appellate authority does not grant, it would be a fresh cause of action that in sessine of the matter without prejudice, I want to exercise this right. I am not being permitted. That would be a fresh cause of action. I meet my learned friend once again.
Heard learned counsel, senior counsel appearing for the petitioner as well as the state. Whose next para, learned senior counsel appearing for the petitioner's contents that in principle, the petitioners do not have any quarrel with the order dated July 31, 2026. Whereby the petitioners were granted liberty to approach the appropriate statutory authority for the self-same reliefs as sought in the writ petition and consequentially to withdraw the writ petition. Next para, however, it is submitted that the petitioners are agreeable to deposit the it's a stamp duty.
Stamp duty.
The stamp duty assessed by the respondent authorities subject to without prejudice to their rights to prefer a challenge to the said adjudication, consequent to which the deed in question may be registered. Next parallel, senior counsel appearing for the state's respondents submits that in any event, if the petitioners are entitled to such remedy in law, they can make such prayer before the statutory appellate authority. Next para, we find substance in the contention of the respondents to the effect that for the relief being sought by the petitioners, no recall of the order dated July 31, 2026 passed in WPO 907 of 2016 is required to be effective. Next para, in the event the petitioners are otherwise entitled in law to have the deed in question registered upon payment of the assessed amount of stamp duty, along with interest, if any contemplated in law, it is always open to the petitioners to take such recourse and or to seek an appropriate order in that regard from the statutory appellate authority, comma, if and when an appeal is preferred against the assessment impugned. Full stop, next para. Thus, comma, this court does not find any merit in the recall application. Full stop, accordingly, GA 4 of 2026 is disposed of by granting liberty to the petitioner to take appropriate recourse to law if available to the petitioners, comma, for getting the deed registered upon payment of the assessed stamp duty and or
Deficit
interest,
stamp duty, deficit stamp duty.
deficit stamp duty and
That's
or
the exact.
interest, comma, if so envisaged in law,
So
and stroke or to seek such remedy before the appellate authority if
not appellate, we will go to the registering authority and or. Oh, very good.
Before the appellate authority if a statutory appeal is preferred against such assessment.
So grateful.
Thank you.
Deeply obliged.
Affidavit says, thank you.
Only there is no merit in the application, my lord, that part.
I was going to dismiss it. But after seeing your faces and Mr. Banerjee's face in particular, I stopped from doing it. Actress ছিল নাকি?
Sure.
You may leave. I'll take up the appellate segment.
Yes. But again, my lord, we are.
You are again there.
Yes.
But today, my lord.
330 resolution.
Oh, definitely I'll take up. Yes, call on the list.
Mr. Sannal has left, but he was there.
Which Mr. Sannal?
Mr. Subish Sannal.
No, he is avoiding the court, Mr.
No.
On every occasion when his matters are taken up, he is absent.
No, he was there, my lord.
Call করতে হবে তো, call করুন।
Mr.
ওনাদের কথা
Subish
শুনবেন না,
was
আমার
there,
কথা
my
call
lord. He was there. আরে দেয়া করবো না।
Yes, who is for the petition?
It is our application for modification of your lordship. Application.
There is merit in it. There's no merit, then why?
It is like
There is no merit in
it is of
But my
my
lord,
side,
I will not make this submission, my lord, in the absence of Mr. It will not be proper on my part.
This is the second occasion when an adjournment is sought in the matter by the appellants. Full stop. By the applicants. Full stop. As a last chance to the applicants to move the matter, the same is adjourned for the day.
আমার পরের দিন তুমি করবে না, আমি last chance করব।
Last chance to you.
Last chance না।
Last chance.
Last chance. কি আছে?
The bench is having to sit every whenever I find time for these matters. This is not done.
No, we will do the matter. We
cannot do this every time.
Next week. My lord, may I request your lordship, my lord, kindly take up these single bench matters at 2:45 or something like that.
No, that peculiar timing does not suit me. 2:45.
3:30 মানে
2 o'clock, my lord. 2 o'clock.
Oh, achha, to avoid 3:30.
Today there is 3:30. That's why Mr. Sannal.
I had 4 benches today. This is the 4th bench.
I know. We are
That's why I'm having difficulty adjusting the timings. And if people don't do matters, Mr. Mujumdar, then it's very difficult for me to fix a time.
If it so pleases your lordship, if it is
not a question of my pleasure, Mr. Mujumdar. It's a matter of convenience
of the court. It's a matter of
convenience means I
waste your lordship's time.
The regular bench also there are so many heads.
Time is
more heads than number of weeks and days in a week.
Any other day, my lord.
Very difficult. Regular bench will suffer.
Friday, my lord.
4 o'clock also.
Because Friday we take up these broken benches.
But if broken 3:30 হয়ে গেলে আর তো গন্ডগোল হয়ে যাবে।
That we'll see.
That we will see, my lord.
Our last chance.
Apart from Mr. Mukherjee, this matter, most of the other matters are already over. So therefore, we are having to sit for just 2 matters are there. Unless it's a new, your application is being adjourned every day. This is the second occasion when it is adjourned. Because have some sympathy for the court also. You have a 3:30 resolution, you can understand. But court cannot indefinitely adjourn matters. We have been honoring 3:30s. We have been honoring 3:30s till now. But for these matters, for special benches like this, both of you are present. You could have done the matter.
Without him,
without him, if you are helpless, we'll dismiss the matter for
you, my lord. Next day,
we are
next day, my lord, 3:30 or not, my lord, we will do the matter.
Please do the matter. I'll definitely try to keep in mind what you are saying. Keep it before 3:30. Definitely try to do that.
So that, my lord, we can avoid.
No, we understand your embarrassment, but it cannot go on happening.
No, my lord.
We appreciate.
I won't take.
Don't appreciate at all.
I think Mr. Sannal will not take more than 20 minutes. I will not take more than 15-20 minutes.
What 20-15? Forget 20-15. Those days are gone.
Total 10 minutes.
Total 10 minutes.
Call for point.
I'm
Can take
grateful,
your
my
losses
lord.
kindly.
Yes, please.
I'm grateful, my lord, deeply of
Thank you. Yes, who is appearing?
My lord, I am appearing for the respondent number 4, 5, and 7.
Oh, yes, that matter. Yes, Mr. Bhattacharya, you have to argue.
My lord, the other side is to argue. I received their reply to the
You have received the reply today.
today.
Oh,
Anyway, if they begin, let them begin.
I have served the written notes.
use the microphone so that Mr. Bhattacharya can.
I have served the written notes of argument today, this morning, my lord,
Achha.
to the.
So, Mr. Bhattacharya, you have not filed any written notes of arguments as yet.
I have filed earlier
Yes.
on the basis
Oh,
of
achha,
that.
you have, oh, achha, you have already filed. Right.
Yes, ma'am.
So, oral arguments were concluded in this.
Concluded, my lord, Mr. Subishanal is appearing in this
So,
matter.
here also, Mr. Channel. It's getting very difficult, Mr. You are Mr. Mukherjee?
Suman Mukherjee.
Suman Mukherjee. So, Mukherjee, you'll have to come prepared on the next occasion if he's not there. You have to start the matter. At least save the face of the court. And we cannot sit indefinitely in these matters. I am sitting for you these two matters only. And both matters, Mr. Chanal is there, he's out of court. He's gone out of court. Just because there's a 330. You have to have some preference for the this special courts which are sitting only for your matters. Otherwise, what will happen? The next occasion, I'll close arguments and I'll pass my judgment as I.
I'm seeing, my lord. 4 benches, my lord.
Very difficult, Mr. Bhattacharya, to adjust time. It's not we are paid to do this job and I love to do my job. But it's very difficult to adjust times. And you have your 330s, that is a difficulty. I mean, for these special benches, I'm requesting Mr. Chanal to just accommodate and do the matters.
My lord, as my lord may fix, I have no objection to anything.
We are keeping it on September 18th, Mr. Bhattacharya. Probably that is the next day when Justice Bhattacharya will also be available. This is single. Yes. So this I can keep next Friday also. I'm making it not today. If there is no other difficulty, then understanding will be that it will be in on next Friday. Next Friday. Very well. Written notes of arguments filed by the petitioner today be kept on record. Full stop. On the prayer of learned counsel for the petitioner, the matter is adjourned for the day. Please keep a watch on the list. We generally publish the list one day before. I mean, if it's on Friday, then we publish it on Thursday, so that you have notice. Thank you, Mr.